Order, order. Tony Vaughan to move the motion.
Thank you, Sir Edward. It's always a pleasure to serve under your chairship. I beg to move that this House has considered E-petitions 727, 372 and 746, 363 relating to indefinite leave to remain. Sir Edward, I open this debate today on behalf of the Petitions Committee, and I'm grateful to the 330,000 people who've signed these two petitions, which evidently has gained a lot of interest given by the numbers of honourable members who have attended. The government is currently consulting on changing the rules around whether, how and after how long somebody who is legally here is entitled to permanent residence in the UK, known as indefinite leave to remain, or ILR. The first petition, started by Lawrence Bansill, who sits in the gallery, calls on the government to protect legal migrants and scrap the proposed 10-year settlement route. The second, from Palasi Wirasangi, calls for keeping the 5-year route to ILR, but to restrict access to benefits to protect the public purse. My mother once had ILR. She came from the Philippines in the 1970s on a work visa. She worked in London hospitals, got ILR, and then British citizenship. She built a life here and cared for generations of patients right to the ends of their lives. One of those patients was a former member of the House of Lords and senior judge, and I remember her recounting her many conversations with him about his distinguished career, as well as about my own legal studies and aspirations, which he showed a keen interest in. She attended... I will.
I thank my honourable friend for leading on this very important debate. Many of my Slough constituents, especially healthcare workers, have signed these petitions about the indefinite leave to remain, and in particular how many of them feel that the goalposts are being moved and this will have a huge detrimental impact on their lives. Does my honourable friend agree that there should be no retrospective implementation of this legislation, because that would be truly unfair on them and on the rest of us?
I thank my honourable friend for his intervention. I do agree with him, and that's exactly the analogy that I was going to use in due course. But as I said, so in relation to this example I was just recounting, that my mother attended this guy's funeral, which she did for many, many patients. And it shows really that this isn't just work, it's a real service to the public, and really in times of critical times in people's lives when they're very, very vulnerable, that is an example of a profession which is extremely important. It's hard work, but it's vital work. But the sector has been plagued by labour shortages for many, many years. And after Brexit shut off the recruitment pipeline from the EU for social care workers, and with a pre-existing recruitment crisis in that sector, a large vacancy problem had emerged by 2021, which led to the Home Office putting social care on the shortage occupation list. And those who came, I will in a second, those who came here to work moved their entire lives here, brought their families here, as they were entitled to do. And they did so when the rules said that after 5 years they could apply for settlement in the UK. That was the deal. I'll take...
I'm grateful to the honourable people who are making a compelling case here. The position is particularly acute in island communities, where we need to bring people in to be part of our community. Their role is welcomed, and we can't just ship workers in from another town or village 10, 15, 20 miles down the road. This extended period of ILR will make it less likely that people will want to settle in communities like mine, because they will not want that extended period of uncertainty in their own lives.
His constituents in exactly the sort of similar position to my constituency of Folkestone Hythe, where there's been a long-term recruitment and retention crisis as a coastal area. You can only go one way, and there are massive, massive problems, which I think will be, I agree with him, worsened by this proposal. I will.
Just so I don't interrupt his flow, he's making a fantastic speech, and I thank him for bringing this debate. According to the Royal College of Nursing, 60% of internationally educated staff without ILR, so it's very likely that the extending this qualifying period will affect their decision to remain in the UK, and that equates to 46,000 nursing staff at risk of leaving the UK. Does he agree that this policy would worsen the retention crisis? And also, does he agree that the government ought to produce an NHS-specific impact assessment on this policy?
Here, here. I thank my honourable friend for intervention. I completely agree with her, and will go on to make those very points. And so that was a deal, but the government is now considering doubling the wait for settlement from 5 to 10 years and up to 15 years in the case of care workers. And one of the most contentious elements of the consultation is that that will apply to people who are already here. And Sir Edward, my position is that I fundamentally oppose that rule change. Migrants entered this country on a contract. The deal was simple. Come to work in the sectors where we need you to work, obey the law, pay your taxes, and you can stay. And changing the terms of that contract after people have spent years building a life here is not just bad policy, it's a breach of trust. It makes Britain look unpredictable and a country like a country that does not keep its word. You cannot talk about earning settlement, I will in a second, you cannot talk about earning settlement if you keep moving the goalposts after the game has started. In my view, retrospectivity is un-British and undermines our sense of fair play. It should be abandoned, and that is the position of the two petitioners who sit in the public gallery, and I wholeheartedly agree with them. I will give way.
Thank you. I thank my honourable friend for giving way, and I'm sure his mother is very proud of him today in the House. My constituents have written to me they're a same-sex couple with a child who fled from Russia because of fear of persecution. They are working here, they're paying tax, and their child is in a local school, fully integrated into the community. They've written to me to say they are 10 months away from gaining ILR, and they really feel changing the rules retrospectively does not honour the commitments that were made to them when they were granted refugee status. So does my honourable friend agree with me that this would be very shameful for our country to turn back on what was promised to my constituents when they first arrived here?
I thank my honourable friend for her intervention. I completely agree with her. It is the question of moving the goalposts that I think really is problematic for most of the colleagues who are in this room today, and I completely agree with what she says. I'll take an intervention.
I thank my honourable friend for giving way. Does he agree, as a fellow lawyer, that it is rather unusual to bring into effect legislation which is retrospective? There have been previous cases where legislation has been made retrospective, but that has been to punish crime. These are ordinary, decent people that we are talking about who've come into this country not only to better their own lives, but our lives as well, and the rest of the community. So does he agree that it is absolutely wrong to have the law applied retrospectively, and it just puts the legal system to a bit of a shame? Thank you.
I thank my honourable friend for his intervention. I completely agree with him, and the common law sets its face against retrospectivity, and that is a principle which should preclude this change. I want to also address a number of other elements of the consultation. The government suggests a system of credits to shorten the 10-year wait for things like social contribution. And now, on the face of it, that sounds reasonable, but I think the proposed definition of social contribution is dangerously narrow. It includes things like the police and the NHS, but it inexplicably, in my view, excludes people like care workers in the private sector. And it seems to me, why are we proposing a bureaucratic minefield of volunteering credits, which could be very, very difficult to verify, while ignoring the immense social value that care workers give during a 12-hour shift looking after our elderly? In my view, their job is their contribution, and that should be the credit. I'm also concerned about... I will.
I thank the honourable member for giving way. He's making a really important case. In my constituency of Waveney Valley, the care sector is one of the largest employers, and local providers tell me that the proposed changes could drive 10 to 20% of people out of the care sector. So does he agree that before proceeding with these changes, the government must do a proper impact assessment on the care sector, and also address the fact that if the NHS has different criteria for allowing settlement routes, that could punish the care sector, which is particularly struggling already?
I thank the honourable member for his intervention. These are, in fact, exactly the points made by the first petitioner who sits in the public gallery, who does indeed work in the care sector. I'm also concerned about the proposal to place lower earners, including most care workers, on the 15-year route to settlement. We've heard the points made by others about the problems in recruitment. It will certainly make the position worse. And during that limbo, you cannot progress. As one of the petitioners, Mr Weerasinghe, told me, he must complete the entire qualifying period on the same job code, meaning he has to stay essentially in the same job. So he can't progress, and it means that he can't move beyond the job that he originally came here for. And at the end of the 10 years, he ultimately pays less tax, and that isn't in the interest of the public, and it makes no sense. If we tell a care worker they must wait 15 years for security, while Australia offers it in 3, Canada in 5, they will simply vote with their feet. We risk becoming a training ground for our economic competitors, recruiting talent, training them up, and then watching them leave for jurisdictions that offer them a stable future. I will give way.
I thank my honourable friend for giving way and for leading on this very important debate, and for frightening people with my very loud voice, I'm sorry. but I wanted to be heard. So does my honourable friend agree with me that this proposal is both unfair and dehumanising, and what this government needs to do is to halt it immediately? Over 1,000 of my Liverpool Riverside constituents signed this petition. I've met some of the care workers in my constituency and here in Parliament, and they are very frightened for their livelihoods and their futures. Do you agree with me? It needs to be halted.
I thank my honourable friend for her intervention. I do agree with her. It's the fear of people who are already in the system, who don't have the stability, who don't know what's going to happen, who've made that huge investment, and fear for the future, who are at stake. I want to address very, very briefly.
I see nobody intervening. There's so many people trying to get in this debate. We're going to try and get them all in. So the honourable gentleman's got to realise every time he lets somebody in for an intervention, they may not be able to give a speech.
Yes, I'll press on very quickly to the end. I just want to address very quickly the public funds issue and integration. Mr Weerasinghe's petition does advocate for restricting benefits for new ILR holders, but in my view this is a political choice, not an economic inevitability. If we raise the core care worker pay by around £4,000 a year, that is a step towards the sector-wide fair pay agreement that Unison is calling for, and then we could bring a single care worker up to the level where they are a net contributor in tax, reducing churn in the sector, and finally rewarding people who hold our health and care system together. And I want to say something very, very briefly about the no recourse to public funds system. Under that system, we know that many migrant families are just one crisis away from disaster, and depriving migrant families of benefits to which they would otherwise be entitled contradicts the government's own child poverty strategy. If we want sound public finances, we need integration. Integrated families are stable, they are renters, they're homeowners, they're taxpayers. You do not build that stability by keeping people on the edge of destitution for over a decade. So in conclusion, I do not deny the government's consultation is based on a potentially legitimate aim of ensuring that the path to settlement for non-nationals is fair and serves the public interest. But on the key consultation points, I would say in summary, first, abandon retrospectivity, integrate those who are already here, honour the contract. Second, regarding the care sector, I understand the fear of leakage, so-called, that care workers get ILR after 5 years and then immediately quit for better pay in other sectors. But a 15-year trap is not the answer. It is a charter for exploitation and slavery, modern-day slavery. Instead, let's look at time-limited sector-specific conditions, possibly requiring people to remain in a sector for a period of time. Third, recognise care work as a valid social contribution. And fourth, do not overcomplicate the penalty system. We already have robust good character rules. We just need to apply the rules we already have. I urge the Minister to listen to the voices we've heard in the petition and today in this debate. Drop the retrospective measures, rethink the 15-year wait. Let us be a country that has sustainable economic migration rules, but remain a country that always, always honours its debts, not just its financial ones, but its moral ones too.
Order. The question is that this House has considered the E-petition 727-372 and 746-363 relating to indefinite leave to remain. Now, we can see there's so many people trying to get in, and we're going to try and get you all in, all right? But I've got to impose an immediate 3-minute time limit. And I've got to tell you that every time there's an intervention, that means that somebody at the back of the queue may not get in at all. So do bear that in mind. But we'll try and get everybody in, and we'll start with Cameron Thomas.
Thanks, Joe Hood. It's an honour to serve under your chairship. Let me begin by thanking my constituent, Palassi, whose petition has led in part to this important debate. I believe that when you make a deal with somebody, you honour it. You are honour-bound to keep it. Ayana does not understand politics, nor should she have to. She began her education at nursery here in the UK, where she began to learn how to interact and play with others. And she made her first friends here in that nursery. Almost 4 years since her father made a deal with the UK to uplift his family and come here to work, Ayana now has many friends at school, where English is one of her strongest subjects. Everything that Ayana has come to learn about the world, she has learned here in the UK. She has no meaningful connection anywhere else. Like any other child, she imagines growing up together with her friends, completing her GCSEs. When she grows up, she wants to be a dancer or a lawyer, as is the nature of childhood. Almost 5 years ago, her father made a deal with the UK. The 5-year route to indefinite leave to remain gave him enough certainty to justify bringing his family here, to plan their futures and guarantee stability in Ayana's formative years. I'm glad that she is yet unburdened by the instability her father now feels. The changes to indefinite leave to remain, as announced by the Home Secretary in November 2025, have caused unnecessary stress to many who have already lived here for several years, who have paid visa fees, the immigration health surcharge, income tax and national insurance. On the 2nd of September 2025, I invited the government to demonstrate true leadership over the issue of immigration, rather than to follow the Conservative Party and Reform UK into the abyss. If the government does have the moral courage to navigate this sensitive issue with compassion, then it must honour the deal it made with such families before the goalposts were moved. Whatever else changes, will the government honour the timeline to indefinite leave to remain as was promised to those who are already here?
Well done.
I think there's few people who are opposed to a robust and fair immigration system, but sadly these plans are not that. They'd rip up the promise on which people built their lives. For workers who were asked to come here to fill skills gaps in our public services and industries, the route to settlement would double from 5 years to 10. Lower paid public service workers could be forced to wait 15 years, longer than the new standard, while those earning 6-figure salaries are offered a fast track of 3. Contribution measured by wages rather than care given, life saved and children taught. And worse still, these changes would apply retrospectively. I want everybody to have time to speak. Worse still, these changes would apply retrospectively. Nurses, social care staff and council workers who came here under one set of rules would suddenly find the goalposts moved, or worse, deported due to harsher income thresholds, with their public sector employers unable to meet the increased salary requirements and their colleagues left behind stressed and overworked. Even after gaining indefinite leave to remain, people would face no recourse to public funds, settled in name but excluded in reality. For women fleeing domestic abuse, for disabled people, for LGBT communities, the impact will be cruel and profound. And these issues also reach beyond skilled worker routes. In the asylum system, charities and clinicians warn that prolonged insecurity deepens trauma and drives people into destitution. Earlier access to work, settlement and citizenship improves outcomes for individuals and for the communities they join. A humane asylum system with safe routes and timely decisions is not an act of charity, it's an investment in social cohesion. Another community unfairly affected are the BNO visa holders from Hong Kong. For them, the 5-year path to settlement must be protected and made permanent. Retrospective rule changes, excessive salary thresholds or language barriers would simply betray the commitment that this country made to people seeking safety and freedom. Children born here should have automatic and secure status, not years of uncertainty. So I'd urge the Minister, stand for dignity, fairness and humanity. Retain the 5-year route to settlement, end retrospective changes, protect refugees and BNO families. Reform skilled worker visas so they prevent exploitation rather than enable it. And above all, recognise the simple truth that those who care for Britain are part of Britain.
Iqbal Mohammed.
Thank you, Sir Edward. It's a pleasure to serve under your chairship. Last week, I held a meeting in my constituency of Dewsbury and Batley with the Nigerian community. There were around 30 workers present, many of whom work intolerably long hours performing vital tasks for scandalously low pay in the healthcare and social care sectors. These people were scared. They were scared the state was going to arbitrarily deprive them of their ability to live with security and to plan with any certainty for the future. One of these individuals, her name is Uzuamaka, wrote to me outlining her concerns. Uzuamaka came to our country in 2022 and works in the NHS. She wrote, and I quote, that I am an immigrant, a taxpayer, a worker and a human being. But the new immigration white paper strips me and others like me of dignity, stability and belonging, end quote. proposals to extend indefinite leave to remain, she quotes, to make someone live in limbo for 10 years despite working hard and paying taxes is cruelty in slow motion. 10 years of exclusion from a future. This is not about integration, it is about humiliation. How can a Labour administration that professes to care about social justice participate in such performative barbarity against immigrants, a group already vilified in the media and subject to acute marginalisation in the wider society? As Uzuamaka writes, this entire system treats immigrants as disposable tools. We are good enough to pay into the NHS, but not to benefit from it. We are needed, but never welcomed. Similarly, proposals that workers could still qualify after 5 years if they earn over £50,000 are, and I quote, a gatekeeping tool. Most healthcare assistants, carers, cleaners and laboratory technicians will never meet this bar. Yet we clap for them, we depend on them, we call them key workers, now we discard them.
Would
End
my honourable
quote.
friend give way?
I will give way.
I thank my honourable friend for giving way. And on that last point he was making, last week over 45 migrant rights groups described the earned settlement proposals as fundamentally racist and classist. So does the honourable member share my deep concerns that these proposals will absolutely hit the most vulnerable the hardest and create a discriminatory two-tier system in which wealth and certain jobs or nationalities are prioritised over others?
I thank my honourable friend for her intervention and I wholeheartedly agree with her comment. We have to have equal compassion for all in our society, whether they were born here or whether they came here to build a life for themselves and support our country in the prosperity that we all share in. So I completely agree. Uzuamaka concluded her letter by asserting that we do not want favours, we want fairness, we do not seek sympathy, we demand justice. So I conclude, Sir Edward, with the following. If Labour politicians did not go into politics to give a voice to the otherwise powerless, such as Uzuamaka, and to fight for a humane state, then why are they here? That is why they must vehemently oppose any changes that would extend indefinite leave to remain or unjustly penalise those on low incomes. And I urge the Minister to strongly look at the proposals that were made by the Home Secretary. These will marginalise even further the lowest earners and the most marginalised in our society. And actually, they contribute they make a key contribution to our society, and it will destroy the fabric of our country, our NHS, the care sector, and many other industries that rely on people from outside of Britain to keep our country running. Thank you.
Harry Gardner.
Thank you. I congratulate my honourable friend from Folkestone Hyde on securing the debate. Legislation should be clear, and the people to whom it applies should know where they stand. Retrospectivity and arbitrary or subjective criteria make for bad law precisely because they destroy that clarity and certainty. Many of my constituents in Brent West are deeply concerned by the government's consultation. I welcome the government saying that they will not change the status of those who have already settled status here. To have done so, they admit, would have been unfair. I quote, "These are people," they say, "who have been in our country for years, even decades. They have families here. They have contributed to our society. Fairness is the most fundamental of British values. We made these people a promise, and we do not break our promises." But we do break our deals, it would seem. Take the family in my constituency who came lawfully to the UK 16 years ago. They didn't meet the requirements for other settlement routes, but after 10 years, they've put down roots. They've had 2 children and were earning just enough to apply for the 10-year path to settlement under the long residency rule. So far, they've paid an FLR application fee of £1,321 per person, plus an immigration health surcharge of £2,587.50 per adult, reduced to £1,940 for their children. That's a total of £14,363, paid not once, but twice, because the fee is due every 30 months. So next year, when the third payment is due, can the Minister tell me whether after already scrimping to save the £28,726, they should double down and pay the third instalment of £14,363 so they can then go on to make the final ILR fee payment of £12,126? Or will their pathway suddenly find that it has been blocked by a new requirement that one of them can't fulfil, and that the £43,089 they've already spent is lost, or perhaps extended, so that they can continue to pay for another 5 years under what looks like indentured service? These people too have been in our country for years, even decades. They too have families here. They too have contributed to our society. We held out a promise to them too. It was a promise of a 10-year pathway. It now looks more like a road to nowhere, except penury.
Ayub Khan.
Thank you, sir. It's a pleasure to serve under your chairmanship. As someone who represents a constituency proud of its diversity, I see firsthand how welcoming talented, hard-working people from around the world enrich our society. That is why the government's proposed changes to indefinite leave to remain hit so close to home and threaten to upend the lives of so many in my area. Few in this chamber will truly understand the insecurity that comes with moving to another country, of building a life while your future, your family plans, and your financial stability rest on political decisions beyond your control. It is therefore no surprise that so many people who contribute enormously to our communities and economy feel frustrated and distressed as the goalposts are moved yet again. These changes are not only unfair. I'll give way.
Oh, I thank my honourable friend for giving way, because talking about distress, one of my constituents is incredibly distressed. They're a dependent of a local business owner, and they contacted me about the ECAA route. They're concerned that proposed earned settlement skilled worker metrics can't be applied to ECAA entrepreneurs who must demonstrate a genuine business rather than meet salary thresholds. So does my honourable friend agree with me that any changes to indefinite leave to remain must properly consider those on the ECAA and any other specific routes?
I totally agree with my honourable member. These changes are simply unfair. But they're not just unfair, they are economically short-sighted and risk driving away the very people our country depends on. Highly skilled professionals make up a small group, fewer than 70 specialist occupations, yet they are critical to productivity, innovation and competitiveness. Employers already struggle to recruit domestically, particularly in STEM. Raising the salary threshold to 50,000 ignores labour market reality and places further strain on businesses already paying visa fees, skill charges and the immigration health surcharge. I noted the honourable member made mention of how much people pay, but there's an added cost, legal fees, which can run thousands of pounds. So these workers are not burden on the state. They pay tax, national insurance and over £1,000 per adult each year through the health surcharge. Many have partners who are also highly skilled and work full-time, yet their contribution is simply overlooked. Most concerning of all is the proposal to extend the settlement route from 5 years to 10, potentially applied retrospectively. People came here in good faith. Doctors, carers, engineers and teachers recruited during shortages on a clear promise of settlement after 5 years. Changing that promise and the years later breaks that trust and undermines confidence in an already punitive system. If the government truly wants a controlled and effective system, it must value contribution over political expediency. So I simply urge ministers to rethink this proposal, protecting existing routes and ensure the UK remains a country that keeps its word. Thank you.
Abtisar Mohammed.
Congratulate my honourable friend for his expert advocacy on this particular issue. As a former lawyer who worked in immigration before being elected to this House, I can say with confidence that the changes announced last year and is expected to emerge through the consultation represent some of the most complex and far-reaching reforms we have seen in decades. We've been told that this is a moral mission about restoring order and control, creating a system that is fair and firm. But if that is the aim, why are we proposing changes that strip away certainty for people who are already here? People who believe that ILR, indefinite leave, was a transitional route to stability and not a moving target.
Will she give way?
I will, quickly.
I thank my honourable friend for giving way. So many families in Reading, such as my own parents, decided to accept their places in the UK, their positions in the UK, and bring their children over on the promise of a stable educational future. We know how transformational education can be for those children to contribute to the economy in future. Does she agree that we must ensure that stability for those who are already here?
I thank my honourable friend for her contribution and agree entirely. There are many people who uprooted their lives, accepted jobs, bought homes and enrolled children in schools and planned their futures in good faith on the understanding that settlement after 5 years was the agreed pathway. Instead, they are now being told that the rules have changed midway through that journey. Retrospective application of this policy would not only be deeply unfair, it would be entirely unjustified. At the same time, the uncoupling of joint routes to settlement would leave families separated for longer periods. Consider a family where the primary breadwinner may be fast-tracked to settlement, while their spouse, the primary caregiver, perhaps working part-time, is left on a longer and more precarious route. Where are the impact assessments for maternity leave, for part-time workers, for carers or people with disabilities? We cannot announce a two-dimensional approach to migration and work out the consequences later, not when this concerns some of the most life-altering decisions people will ever make. I know that these proposals are under consultation, but we must be clear about the direction of travel. They risk recreating the very conditions that defined the hostile environment, long-term uncertainty, barriers to stability, and communities living with the constant fear that the rules could change again. When my constituents hear migration described as a destabilising event, migrants framed as a burden to be managed, and see policies recycled from failures of the past, they know that this is not reform. They know it is a road to insecurity and division. I want to put on record that the congregations of St Mark's and St Mary's in my constituency have presented me too with a petition urging the government to show compassion and to urge for suitable transitional arrangements for those who are already here, building their lives and contributing to our communities in Sheffield. They, like many of my constituents, know that these proposals lack humanity. They know that they will impose extraordinary hardship on friends, neighbours and the wider community. And they know that a country that truly believes in sanctuary does not make belonging something that has to be earned again and again and again over a lifetime. I urge the Minister to end any retrospective changes and to retain the 5-year route for people already here.
Wishart.
Thank you ever so much, Sir all the grotesque and grim things that's been conducted in this race to the bottom with reform conducted by the Labour and the Conservative parties, this is by far the most grim and the most grotesque. In my constituency, I've met countless families who will be on the wrong side of this. Families who don't deserve any of this, who have done everything that has been asked of them. They work, they study, their children speak with a Scottish accent. And Scotland is the only home that so many of them have ever known. They are cherished members of our community. Yet many of them still wake up every morning unsure whether the life that they are building for themselves and their family will be taken away. That is why indefinite right leave to remain matters. It's the difference between planning for the future and simply enduring the present.
Just very quickly to add, the voice of the Hong Kong BNO is in the Harpenden and Berkhamsted constituency who feel just like that. And one says, we built our lives, our careers, finances, childcare and caring responsibilities on the rules that were promised by this government, and that this limbo, this instability is a disgrace, and if the honourable member would agree with me.
Absolutely. When people are given that security, it takes away that limbo. And I don't know if many people around this room could imagine that type of uncertain status. And this is what people have to live with every every single day of their life. People, because of this, people will remain in the immigration system longer. They face repeated application, fees, health charges, and often legal costs. Illness, injury, or redundancy can throw everything into question, and it might even be penalised. What is most unforgivable, though, Sir Edward, is that this government has left open the possibility that these changes could apply retrospectively to people who have already started their journey towards citizenship in the UK and who are building their lives under the current rules. This is a profound betrayal of those who trusted the system and have made the UK their home. Sir Edward, I've got a large Sri Lankan community in my constituency of Perth. They're partly, almost exclusively, responsible for keeping our social care service together. I met them a couple of weeks ago. They're telling me they're going home. They're going home just by the threat of this. They've had enough. They don't want to be treated like this anymore. And they're refusing to go along with some things like this. And I have to say, I don't blame them. But I worry, Sir Edward, where will we get the staff to replace them in a Scotland that's in the early stages of depopulation and has some of the most challenging demographics in the whole of Western Europe? They are irreplaceable. Even better than this, migrant families, even more than this, migrant families are already in survival mode, working long hours and low-wage jobs, saving for these Home Office fees and living in insecure housing. Some risk destitution simply to keep up with the cost of maintaining lawful status. These pressures leave little time or energy to contribute for these volunteer initiatives that's going to be required of them. They have grown up here and they know other home other than this. Now, I'm looking round this chamber today and I have to say, it's so encouraging to see so many, I see so many Labour members here today. So I say to them, get down to the PLP this evening, put your case forward. Let's make sure that they know the voice of the Labour members of this House. And please, for goodness sake, get another one of these famous U-turns.
John McDonnell. John McDonnell.
Through you, Chair, can I address the Minister? Just read the room. Read the room. The only other times when it's been as packed as this in recent period when I've been here has been the two-child limit and on the welfare benefits. I don't want to see our government have another embarrassing U-turn like this. The reason we're here is because every one of us will have a case that, if this goes through, will be absolutely tragic. Families have settled, sold their accommodation and everything in their home, worked hard, delivered everything asked of them, and we're going to deny them and their children the right to the future that they hope for. And I just say, if this goes ahead, every one of us will report social care collapsing in our constituents. Can I also remind people that as many of these workers have been past experience who delivered us through COVID as well, some of them sacrificed their lives as well. This is just unjust. And I think the Minister needs to recognise that, take the message back to those who are developing our strategy as a government, say this isn't the route to go down. Can I just say this one final point? I'd rather not, because other people need to come in. Let me just make this point about parliamentary process. If this isn't to be done through primary legislation where we can have a debate and amend the legislation, if it's to be done via a statutory instrument, it needs to be the double affirmative process so that we can have a debate and offer the opportunity of amendments. Because otherwise, I think the government's going to run into a scale of opposition that's seen on other issues, frighten people, undermine our support completely unnecessarily. If there's issues around immigration we have to deal with, and we did it through the colleges, if people can remember when there were bogus colleges, we did it through proper legal process and prosecution. If there's abuses in this system, let's address the abuses. But don't harm people in this way as a result of that.
Charlie Maynard.
Thank you, your chairmanship, and I thank the honourable member for bringing this important debate.
I met with a constituent this morning, Petra, who has been in the country for 3.5 years. She works in the care sector. She works extremely long hours, which are not in her control. Sometimes she is loaded with hours 6 days straight from 7 o'clock in the morning to 10 o'clock at night. Sometimes she gets no work at all. When she talks to her employer, they say, well, you know, you and the rest of your team, you are on visas, and if you report us and we go out of business, then you're all going to be leaving the UK. And this is just this enormous class of indentured servitude that we are creating.
On that point, will you give me very briefly?
Certainly.
Thank you. I really appreciate it. Giving way. Those were the words exactly of my constituent Arshad Khan this weekend when he came to see me at my constituency surgery, that indentured servitude point that we've made about visa licences and how these people actually operate. And there's been many points made here, so I just wanted to add strength really to his argument that this is a serious point about people living with the power of their employers over their head and being held sometimes on poor rates of pay, on poor shift patterns, and they can't challenge it because their employer has all the power in the relationship. Thank you.
Thank you. This is obviously cruel, and this moving of the goalposts makes it miles crueler. And to your point, sir, about reading the room, I really hope that the Minister is reading this room, because I think the country is up in arms about this, and we should not allow this to go through. And I really ask the Minister to reconsider.
Yeah.
Mark Sewards.
Thank you, Sir Edward. It's a pleasure to serve in your chairship today. I want to start by saying that controlling our borders is a basic function of the state. The government inherited open borders and is now undertaking the serious work required to fix them. And I do welcome the Minister's efforts, but I do think there are some tweaks we can make. I've spoken on this issue several times before, particularly about the BNO Hong Kong visa holders, and I'm grateful that the government has committed to keeping the 5-year route for those affected. Today, though, I'm going to focus on how these proposed changes will affect families, especially those I've been speaking with in the Morley Indian community. Now, around 30% of the families I've spoken with are due to receive their ILR within the next 6 months, so they are understandably very anxious about what these changes mean for them. The vast majority are high earners or work in key sectors. Many of the families I spoke to, many of the people I spoke to, will earn well over £50,000. They don't claim benefits, and they contribute significantly to our economy and to our public services through their taxes. Now, it's because at least one member of these families is earning a high salary that their spouses and partners have been able to move into part-time work, often so that they can help raise the children and care for them. Now, as a result of this situation and the proposed changes, that they are now very worried they will not meet the new criteria at the same time as their partners. They came to this country under one set of rules, which allowed dependents to move to the UK with them, and now they are very concerned at the prospect of being unable to qualify together and being broken up entirely. So my first question to the Minister is, has the government considered putting in place strong transitional arrangements that do not punish families who are already here, contributing far more to the UK than they take out? Or would the government consider that where a family, not an individual, meets the salary threshold, they can qualify for ILR together? And just one more point with the extremely limited time available to me. Many of the Morley Indian families I spoke with came over here knowing that while they were waiting for ILR, they'd pay international university fees, and they accepted that those were the rules. However, under these changes, they now might be waiting a lot longer, but worse still, they're going to find that if they do go back to India, they're no longer considered home students for the fees purposes there. So they find themselves trapped in a situation where they can't pay the fees here and they can't pay the fees back at home. I would ask, very briefly.
I thank my honourable friend for the speech he's making. Does he agree with me that while the government seeks that these proposals increase integration, that actually we risk, by limiting ILR beyond 10 years, we're actually going to reduce integration in the type of instances that he outlines, and that risks undermining the integration that I see in workplaces, churches and community groups in Sunderland that I represent?
thank him for his point. I completely understand where he's coming from, and the people that I was speaking about in my point just before he made his intervention, they're going to find themselves trapped and effectively shut out from university education altogether, even though that they are already integrated into this country. So, Sir Edward, I just urge the government to consider the full impact of the implementation of these changes for people who are already here, already working, already contributing more than they ever take out, who came in good faith, and who have followed every rule we have set for them.
Well got, Adam.
And hence it's very difficult for me to know where to begin, but I will do by thanking the petitioners, and also for this MP at least, and indeed many that I can see in this room, and cabinet ministers and shadow cabinet ministers, and even a prime minister. I am what I am because of when I came to this country in the manner this country treated me. I have two parents who couldn't speak a word of English, yet the support that we received means that now we have a dynasty of academics, entrepreneurs, professionals, and even a parliamentarian. I know that might be enough for a policy for people to make sure that never happens again. But we have a sense of belonging to this land, even though we are far away from our ancestral land. This does not happen by chance. It happens by design and can only happen in a country that promotes integration based on values of decency, respect, and contribution, rather than contempt, impatient, and transactional values. It works when a society respects values that should be woven into its fabric. When we value our care workers, our frontline health workers, our teachers, our transport workers, not because of how much money they earn, not because of their salaries, but because they are a foundation of our societies.
Very briefly, the point he makes, a lot of people who've come here have been branded the Boris wave. But one of my Nigerian constituents told me that they came here under the COVID wave to care for people in this country.
I agree with the gentleman, thank you. This policy also flies in the face of the Prime Minister's pre-election pledge. It is a betrayal of his sixth pledge, an immigration system, we were told, rooted in compassion and dignity. This is a betrayal felt, for me, and I'm sure for many, most sharply when it is an Asian Home Secretary, someone whose own journey reflects migration promise, now advances policies that punishes people just like her family and mine once were. And apart from being morally bankrupt, it also flies in the face of fiscal responsibility. We are told this is all about cost, that migration is a burden, yet even those claims collapse under scrutiny. The widely cited £234 billion ILR emergency figure has been discredited even by its own authors. Correct the errors and migration delivers a net fiscal gain of £100 billion. Sorry, in the interest of time. Security results in integration. Insecurity results in chaos, and not to mention serious possibility of exploitation by employers, the indentured labourer point that has been made by my colleagues before. So when did modern Britain become such a transactional country? If we truly want an integrated Britain, the last thing we want is longer waiting times, uncertainty, and a broken promise. What we need is certainty, 5 years maximum with fast decisions, and a real acknowledgement that migration, when done with respect and fairness, strengthens a country, not weakens it.
Yeah. Melanie on.
Thank you very much, It's a pleasure to serve under your chairmanship today. Proposed changes to ILR and the consultation on earned settlement have far-reaching consequences. It is essential that they are delivered with fairness and compassion. I do support the government's mission to restore control and confidence in the immigration system, including the clear objective of reducing net migration and ensuring the rules are properly enforced.
Hear, hear.
Public trust depends on a system that is coherent, that is consistent, and that works. But I do think that it's worth remembering that the people who have come to the UK, they've come through legitimate means. They've come to fill the Brexit work gap, to support our public services and to contribute well to our society. And I have to reflect the real anxiety that I'm hearing in Great Grimsby and Cleethorpes from people who are already here, already working, already paying tax, and who entered the system in good faith under the existing framework. They've built their lives around their rules, these rules, our rules, and it'd be wrong if the goalposts were moved halfway through the match. I want to add the voice of one constituent, Victor Olabumoya, a care worker who described living under what he called visa fear. He told me that he went to work every day fearful that a single mistake could cost him not just his job but his immigration status, and that managers repeatedly reminded him that his visa depended upon them, as we've heard from others today. And in Victor's own words, he says, "You cannot give what you do not have. People who are treated without dignity struggle to give dignity." And that testimony matters because it goes to the heart of what fairness looks like in practice. If we want a system that commands confidence, we must not create incentives for silence or exploitation and instability in our essential services. I think change for future arrivals probably can be just about explained, but retrospective change for those who are already here, often working in our essential public services, really risks undermining workforce stability and basic fairness. And my constituency, the issue of immigration is a topic of interest, to say the least. There's no point in pretending it's not.
Absolutely.
But it really isn't about those who've come on a proper visa, through a proper scheme. The concerns about employer, from the government, the concerns about employer over-reliance on overseas labour is not the fault of these individuals. They're here because we asked them to come and help. So as this consultation progresses, I'm asking for careful consideration of transitional protections or differentiated arrangements for existing workers, so their contribution is properly recognised, their integration is supported, and their concerns are reflected in the final policy.
Hear, hear. Mike Martin.
Oh, I stumbled a lot.
Chairship, Sir Edwards. On Saturday, I met with 200 members of the Paddock Wood Hong Kong community. Now, Sir Edwards, you're probably wondering why 200 people would give up their early Saturday evenings to see me. But they were worried, and they were worried for themselves and for their families. They came to voice a fear that their pathway for settlement had narrowed. They came because the conditions under which they uprooted their lives in Hong Kong and came to Britain were being changed. And Chair, I was deeply disappointed because they came on a promise made by the British government, and that is a promise that is potentially now being rewritten. Yeah. Let's go into some detail. I'm grateful that the Hong Kong B&O route is going to continue to allow settlement within 5 years. But there have been two changes, and one of them is about language and one of them is about earnings thresholds. So on language, many of the B&O families came as 3 generational units. And in a 3-generational unit, you're of course going to have people who are quite elderly. And so for those people, quite obviously, to achieve a much higher standard of English proficiency is much more difficult. Honourable members who've ever learnt a language in their lives will know that it's much easier when you're 20 than when you are 80. So what are we to do? If you're 80 and you fail a higher language requirement, will you get sent back to Hong Kong when the rest of your family remains? We need more detail. The government needs to look at this in more detail. And to the income requirements, well, as I said, we had these 3 generational family units coming, and often, 70% of B&O visa holders are degree educated, and they are working often in jobs that's significantly below their professional level and standing. But I won't take any interventions because there are so many people seeking to get in. But what this means, this combination of high-skilled individuals, yet 3-generational families, is that, quite rightly, not everyone in that family is going to work. So what about the carers, the part-time workers, the elderly, the students? If one studies at university and you are not earning, do you need to meet the income threshold? There is a complete lack of clarity. When I attended the Chinese New Year celebrations last year in Paddock Wood, and these were held jointly with the congregation of St Andrew's Church in Paddock Wood, I saw firsthand just how deeply that community enriches our community and how that was reciprocated from the native Paddock Wood community. And so I just urge the Minister, in conclusion, the British government has made a promise. The British government should stick to its promises, and I urge them to reconsider.
Brian Leishman.
Good Good afternoon, Sir Edward. St. Mark's Gospel says, "Thou shalt love thy neighbour as thyself." With the political discourse of today largely focusing on blaming immigration for the societal ills our country faces, that commandment is sadly not in fashion. The government's proposal for pathways to settlement introduces a new 10-year baseline for people, including those granted refugee status, with time added or taken away for circumstances seen as favourable or unfavourable to the Home Secretary of the day. If someone was to arrive by illegal routes, then this adds 20 years to this baseline, meaning 30 years before they could apply for citizenship. Bear in mind that arriving by an irregular route is almost unavoidable due to the virtual non-existence of safe and legal routes. It really must be acknowledged that claiming asylum is a human right. Claiming asylum is not an abuse of any system. And proposals that differentiate between regular and irregular arrivals are unequal at their very core. Differentiating would create an inferior class of people whose protection needs might well be internationally recognised, but their long-term status is being kept deliberately precarious. In a Scottish context, the Scottish Refugee Council have said that in Glasgow last year there were over 2,000 children from refugee families in temporary accommodation. Scottish local authorities are already at breaking point with over a decade of underfunding, over £1 billion these last 10 years from the SNP Scottish Government. And we all know that children growing up in poverty has a huge long-term impact on life chances, health outcomes, our local and national economies, and on the condition and functionality of our public services. So, I say to the Minister, Labour must do better than copying the right-wing parties and demonising immigrants and asylum seekers. This country doesn't need us or want us to be some diluted version of reform. Whether we are talking about immigration, welfare, education, the environment, industry, or all the rest of it, ultimately, the question is always the same. What kind of society do we want to live in? One that looks after the most disadvantaged, vulnerable and destitute, or looks to scapegoat and point the finger at these people for the political decisions that have led to growing poverty and inequality. As a socialist and as someone that believes in the commandment of love thy neighbour, then I know what I want my government to do.
Yeah. Ian Solemn.
Thank you, Sir Edward. It's a pleasure to serve with you in the chair this afternoon, and I'm grateful to the petitioners for bringing this important matter to Parliament and to the Honourable Member for Folkestone and Hythe for leading the debate off. The government is right to say that settlement should be earned through contribution. I think few would dispute that principle. The consultation documents point to a system that contradicts those stated goals on this. I'm sure the Minister will say that today that no final decisions have been made, but the direction of travel is clear. A 10-year baseline for most routes, 15 years for care workers, as many members have mentioned today, with complex reductions based largely on salary. That fundamentally misunderstands what settlement is for. The key I will give way.
I'm very grateful to my honourable friend for giving way. He makes a very good point about salaries and that income levels are not necessarily a good predictor of usefulness to society and economic contribution. We've heard that very clearly about social workers, but does he agree with me that in high-tech sectors such as space, biotech, robotics, etc., we need global talent, and only by pooling those talents will we succeed, and that's why we should not be putting these barriers to indefinite leave to remain in place?
I absolutely agree with my honourable friend, and indeed I will cite an example of that from my own constituency shortly. I think the key distinction to make is between selection and settlement. Our visa system is the selection mechanism. We judge whether someone has the skills we need, meets thresholds, fills a genuine vacancy. Settlement is about whether people can actually plan a future here and commit to staying. 5 years of working, paying taxes, learning English, staying out of trouble, that is earning it. Extending to 10 or 15 years doesn't raise standards. It just makes Britain unattractive to exactly the people our visa system says that we should be welcoming. Let me give a concrete example. I have a constituent who came in on the high potential individual visa, a route explicitly designed to attract the world's best talent. He's a skilled engineer. He chose the UK based on the clear 5-year pathway. He tells me, had a 10-year route been the policy, he would never have come. That's the reality when we're competing for talent. Now, the government also claims the changes will improve integration, but uncertainty is the enemy of integration. Someone who knows they can settle after 5 years will invest fully in their future here. Someone facing 10 to 15 years of uncertainty keeps their options open elsewhere. Another constituent who's been in touch is an orthopaedic surgeon, a professional serving our NHS. He has 3 children in British schools. He tells me that if these rules change, he cannot wait for another 6 years. He will leave, and our NHS and our country will lose him and his talent. The moral stakes are clearest when I hear from Hong Kongers in my constituency. While they may be exempted from the extension to 10 years, the consultation leaves unclear what earned settlement actually means for them. Higher English requirements, income thresholds, whether any exemption is permanent. That's for people who fled political persecution based on our word to them. When we create uncertainty for people who follow the rules and contribute, it damages trust in British commitments. By all means, use the visa system for selection, and we can have many separate debates on that. But settlement terms should enable the people we've decided to welcome to actually commit to staying. The current direction undermines both our own economic interests and our reputation for fairness, and I'd urge the government to change course. Thank you.
Gareth Thomas.
Thank you, Sir Edward. I choose to raise my concerns about plans to require skilled workers, health and social care staff, those who are fleeing persecution, to have to wait 10 years, even 15, instead of the current 5 to secure indefinite leave to remain. And in so doing, to echo the concerns of many in the Hong Kong community in Harrow, equally concerned about their status and their route to get indefinite leave to remain. I think these changes will, as they stand at the moment, make it more difficult to attract to the UK the key staff and talent to help grow our economy and run vital public services. Of course, we need to do more to help those born and bred in the UK to access the jobs market and to prevent abuse of the existing immigration system. But to ask those in the UK already here to have to wait another 5 years or longer would be the height of unfairness. Multiple constituents of mine in senior roles in engineering, in the tech sector and other professional services have written to me with their stories underlining their personal commitment to the UK and the expectation that Britain, of all countries, with our respect for the rule of law, will honour the implicit promise that we would hold true to that 5-year commitment. At the very least, I believe that there has to be transitional protections for those on the current ILR pathway. I am concerned that too often we shy away from recognising the economic contribution and cultural contribution that those from outside our country who make the UK home make to our communities. It is not Britain being exploited. We gain from the talent, imagination and hard work that migrants bring to our country.
On that point, will my honourable friend give
I
way?
will.
Thank you. Thank you for giving way. My constituent, Amin Bhai, a pharmacy dispenser, a skilled worker from India whose work is essential to our community, raised concerns about recruitment and retention in health and social care roles. Alongside our investment in homegrown talent, does my honourable friend agree with me that we must make sure changes to ILR qualifying periods doesn't risk impacting sectors where we currently have heavy reliance on the talents of dedicated international workers?
I very much do agree with my honourable friend. And I would add too that surely we have a responsibility to stand with refugees fleeing appalling conflict, those from Ukraine, those fleeing increasingly authoritarian regimes, such as those from Hong Kong. will you forgive me if I don't, as I've taken one intervention already? Overwhelmingly, migrants, whether they're from, in my constituency's case, from, for example, Pakistan, from the Caribbean, from India, Sri Lanka, or across Europe, have benefited my constituency. Those who work in the NHS or social care, are we sure we want to lose those vital workers from crucial public services? I think international students make a positive contribution to our economy and our country too. I'm certainly proud of the many Indian students attracted, for example, to the UK who live in my constituency. And I do worry for our universities, for example, for the research their fees help fund. Cutting-edge universities in Britain need to attract international students, so we should not demonise those students who come here and drive them towards other countries' universities. I recognise the choices before my honourable friends in the Home Office are not easy, but I urge them nonetheless, in particular, to recognise the particular responsibility we have to those who are already here, who are already on the ILR pathway.
It's a pleasure to serve under your chairmanship. Last week I met with 30 or so members of the Hong Kong community in Horsham. These people are professionals. They are teachers, students, engineers, doctors, business owners and directors. They are in work, paying tax, buying homes, raising families and contributing to local life. They came here legally. They came because the British government made them a promise. In talking to them, what struck me most was not anger, but fear. Fear that the basis on which they uprooted their lives is now shifting beneath them. Given the strength of feeling, the numbers affected, and the unique historical context as a former colony, I trust the government recognises that their recent changes, proposed changes to indefinite leave to remain, have or will have unintended consequences, and that this is a matter that they will want to address urgently. In Horsham, nearly 90% of B&O households are homeowners. Clearly, they are not a drain on public resources. They are financially stable, yet some will nevertheless struggle to meet the new income threshold. Some family groups include older applicants, carers or non-working spouses, just as you would expect in any household. Many cannot simply earn more to bridge the gap, and others will take time to move into higher paid work and transfer their skills and qualifications. So I asked the Minister whether the government will consider taking account of assets and long-term stability, not earned income alone, when assessing ILR applications for Hong Kong B&Os. My constituents are also deeply concerned about the English language requirement. In Horsham, 4 in 5 of them say that they are worried about passing the exam. And they are people that seem quite fluent when I was speaking to them. Obviously, it affects older applicants in particular. These families moved across the world on a promise from the British government, and there's now a genuine risk that that promise will be broken. In all honesty, I don't think this new law was ever intended to affect them at all. So my asks from the Minister are straightforward. Exempt Hong Kong B&Os from the new earned settlement criteria, provide transitional protections for those already on the 5-year settlement pathway, and assess household income, not individual income, to keep families together. Thank you.
Witherden.
Sir Edward. I wish to place on record my firm opposition to proposals to dramatically extend the timeline for the route to settlement, and in particular to the deeply unfair plan to apply these changes retroactively. To now withdraw that promise is, as the Workers' Rights Centre has rightly said, an extraordinary betrayal of migrant communities. These proposals risk fueling exploitation, deepening poverty, destabilising already fragile sectors and doing real harm to the wider economy. Under the new system, so-called medium-skilled or lower-paid workers, including nursing, healthcare and social care staff, could face a staggering 15-year wait before being eligible for settlement. This is not a pathway, it is a prolonged period of insecurity. Last Thursday, I met with a group of local Unison members, all migrant care workers. Their dedication to our community is unmistakable. One told me that he regularly completes a long shift at Newtown Hospital, volunteers at Newtown Food Surplus afterwards, sleeps for 4 or 5 hours, and then begins his next shift. I cannot think of a clearer example of someone who gives wholeheartedly to their community. At a time when our care sector is already facing critical workforce shortages, these proposals will drive people away. Research from the Royal College of Nursing indicates that up to 46,000 nursing staff could leave the UK in response to these measures. That would be catastrophic. So I ask the Minister, what assessment has been made of the impact on staffing levels in our public services, particularly health and social care? And does the Minister recognise that forcing care workers into 15 years of temporary, precarious status risks destabilising the workforce even further, increasing delayed hospital discharges and placing yet more pressure on unpaid family carers? We must retain the 5-year route to ILR. We must halt the retrospective application of these changes. We must honour the terms that workers originally signed up to. And we must invest properly in social care, advancing the Fair Pay Agreement and protecting the rights and status of existing international recruits. It's not migrants who have weakened our public services. Successive governments have done so through underfunding and privatisation. Our migrant workers keep our health and social care system afloat. Punishing them with prolonged insecurity will only deepen the recruitment crisis and harm families and communities across the country. Diolch yn fawr.
Charlotte Kane.
Thank you, Sir Edward. I'd like to congratulate the petitioners on bringing forward this important debate. The government's immigration white paper has caused no end of confusion, anxiety and distress since its publication last year. To me, and for countless constituents who've contacted me worried for their livelihoods, it's profoundly and inexcusably unfair. Some don't know whether they should prepare to leave or continue with plans to invest in a new house, a job, marriage. Others are seriously worried about the status of spouses and dependents under the new rules. They're facing the reality of being entirely displaced, forced to abandon careers and personal lives, their colleagues, friends and homes. I've written to the Home Office, raising the fear and distress of my constituents and urging that at the very least they offer some certainty on indefinite leave to remain. Yet time and again I receive the same formulaic lines from the Minister, who refuses to provide the assurance that changes to ILR will not be applied retrospectively to those that arrived under the 5-year rule. Instead, my constituents are told that they must now earn their right to settle by attaining a minimum income level and proving their worth through volunteering. Numerous individuals have been in touch to tell me how upon their arrival in the UK, they spent time to complete degrees and master's degrees and on-the-job training to secure their places in valuable sectors such as science and innovation or our NHS. Now they're unsure if they can stay or if they can trust that even an extended ILR term will ultimately ensure their settlement. Others with jobs in areas such as adult social care, putting in long hours to ensure they're on track to settle status. Between putting in long, unsociable hours, doing invaluable work in our social care system, they don't have the time to further prove themselves by volunteering. Women are particularly disadvantaged, a fact which the government is yet to acknowledge. Whether it's due to limited access to skills, the gender pay gap, greater caring responsibilities, or taking maternity leave, they too fear they'll not meet the government standards to earn their settlement. The government's planned changes to the immigration and settlement system are wrong, and they treat with contempt the countless people who came to this country fairly and planned their lives around the rules at the time. At the very least, I urge the government to treat these people with the respect they deserve. Will the Minister now rule out once and for all any retrospective application of changes to ILR and the addition of any new requirements to those already on the path to settled status?
Thank you, Sir Edward. It's a pleasure to serve under your chairship today. And the proposals to retroactively extend the qualifying period for indefinite leave to remain create considerable insecurity and disruption for migrants living in the UK. Contrary to what many believe, the process of getting ILR is a difficult and costly exercise, so there's no need to make it even more difficult by increasing the eligibility period. We're not talking about new arrivals. These changes will impact those who have lived in the UK and contributed to our economy for at least half a decade. They are nurses, doctors, train drivers, construction workers, cleaners, carers, and others who keep our economy working. Thousands of migrant workers in these sectors are now being told that we do not value their contribution, and we risk losing these skilled workers, which would undermine our public services and our economy. I'd like to declare my interest as the chair of the APPG on healthcare workers. Now, the NHS and social care employs thousands of people on work visas to cover workforce shortages. Like one of my constituents, a healthcare assistant living in limbo due to these proposals, with a salary just £60 a year under the arbitrary threshold. And while we do not have robust data in that area, Conservative estimates suggest around 25,000 doctors, around 50,000 nurses will be impacted. So, as others have asked today, can the Minister confirm what data modelling or impact assessment has been conducted to assess how these changes will affect the health and social care sectors? After many years of failing to provide enough places in medical school, apprenticeships or other appropriate career training, we face labour shortages in many industries across this country. So we rely on immigration to fill these gaps. These changes make the UK a far less desirable and far less fair place to live and work. And those who have made their home here, these changes say to them, you're not welcome. So let us show those who have built their lives among us that they are supported, they are valued, and that they are truly welcome in our country that they also call home.
Yeah. It is Amos.
Thank you. To serve with you in the chair. I like to thank the 344 and 511 signatories from Taunton and Wellington who signed this petition, and including Ada Cunley, who is here today in the public gallery. Everyone recognises that the immigration system needs to be controlled, needs to be workable, but this debate isn't about the immigration system. It isn't about people who may come here or are thinking of coming here. This is about people who are here, who have answered our call to come here and work in our health services and in our country. They've settled here. They're already providing that vital work. And these changes, extending ILR requirements from 5 to 10 years, would remove from my constituency in Taunton and Wellington care workers and potentially care services people need and rely on. I don't know who the government thinks will vote for the removal of care and care workers from their constituencies. It cannot be right to change the rules after people have made that big decision to uproot themselves, their lives, and invest their lives halfway around the world to be here. We have had a period of chaos in immigration. It's absolutely correct. The Conservatives lost control post-Brexit. Net migration jumped from 300,000 to 1 million in 2023. They loosened controls. They made promises. They made promises about settlement. And now they, and apparently the government, want to break promises made by the government to those workers who responded to Britain's invitation to be here, to move their lives here, and to build their families and their futures here in this country. Faith does need, of course, to be restored to that immigration system, but after that period of chaos. But you don't restore faith in a system by breaking the promises on which it is built. You don't restore faith by casting people out. To do so would be a breach of promise and a breach of trust. Patience, a care worker in my constituency, her family of 3 chose to be here, thrilled by a new life. Since the announcement, their family, she says, had turned quiet, and their 2-year-old son is constantly asking what's wrong. Ada Cunley had two toddlers here who are born here, who know no other country. They have no recourse to public funds. They now feel unable to raise concerns he now feels unable to raise concerns even about people he cares for and the quality of that care because of the risk of exacerbating the risk under that indentured servitude we've heard about. Effectively, sending people away, breaking that promise would have massive impacts on older and vulnerable people in Taunton and Wellington. If 50 care workers are expected to leave, then 100 people could lose that vital care. The government should instead honour the promise made. Do not change the goalposts after the game has begun. It must maintain the rules, including for Hong Kongers based in the UK, and build on the success the workers have brought us.
As a proud daughter of immigrants and proud to represent a constituency where we celebrate and cherish the contributions of migrants from all walks of life, from all around the world, including many frontline workers and carers, and in an area where we reject the hatred, division and intolerance of the far right who continue to target our area. Madam Chair, in debates and discussions about the proposed measures, the government have continued to point to the ongoing public consultation, which is closing on the 12th of February. However, I must take the opportunity today to ask the Minister on behalf of many of my constituents who have been in touch with me the following. When will the impact assessments be published, given the potentially wide-ranging impacts on all of our communities and the economy, including on local authorities and voluntary service providers? How does the Home Office reconcile the potential impacts of these proposals on migrant families with the government's wider commitments to reduce child poverty and homelessness in particular, as laid out in respective strategies published last year? How can the Home Office justify retrospective applications of these changes to more than 1 million people who came to the UK on the understanding that they will be able to settle after 5 years? And for the educators in my constituency, many of whom contacted me over the weekend, will the changes apply to all staff in the education sector? Because, as we know, professional services staff in the education sector play an essential role too, but their salaries make alternative settlement routes inaccessible. Madam Chair, I am alarmed, like many of my constituents, about the harm that these changes will make and have on our population. It will undermine integrity, integration, workforce stability, child poverty, and our ambitions to tackle violence against women and girls. And so, in the short time that I have today, I urge this government to immediately pause the implementation of any changes. The numbers of MPs, members in this room, and indeed the petitioners in the gallery and the queues that are outside this hall today should send a loud and clear signal to the government to pause, to ensure that they support transitional protection so people in the UK are not retrospectively moved onto longer routes. I urge the government to also undertake an independent assessment, ideally by the Migration Advisory Committee, covering areas such as exploitation, domestic abuse, child poverty, workforce retention and local authority costs. And finally, I insist on a wider parliamentary debate and a vote rather than major reform by immigration rules. Thank you.
Thank you, Chair, and it's a pleasure to serve under your chairship. And I thank the Petition Committee for securing this important debate. I speak today because Ilford South ranks second in the country for the number of residents who signed the petition calling for the 5-year ILR route to be maintained. In short, don't change the rules, don't change the goalposts mid-game. At the age of 7, my parents left the life they knew in the Punjab so their children might have a better future. Life here was tough. We had to work hard. Those values of sacrifice, hard work, contribution are still alive in the families across Britain today. Families who have come here lawfully, fill vital skill shortages, give up stability, work hard, pay their taxes and contribute fully to British life. Let's not let them down. I accept the government's diagnosis that our immigration system is no longer fit for purpose. It was allowed to fail under a Conservative government that lost control of that system, left people waiting in limbo and offended our sense of fairness. Now in government, we must restore order, but restoring order must never mean abandoning fairness. British fairness is clear. When people play by the rules, we honour our side of the bargain. Changing the 5-year ILR route retrospectively for those already on that pathway breaks that principle and is wrong. Since the white paper, I have heard countless constituents asking for just one thing: do not change the rules for those who have already complied with them. This was the framework they relied on when they uprooted their lives. Changing it after the fact plunges families into uncertainty.
He's making a really powerful point. Does he agree that the changes to his rule could also have an impact on children, and we have to make sure that whatever the changes are, that they take into account that there are those children who are growing up in this country and who have base here who could be adversely impacted if we do not look at this carefully?
Thank you. My honourable friend makes a really pertinent point, and I absolutely agree with what she has said, and we cannot overlook that the children will be adversely affected. Nearly 3,000 residents in Ilford South signed the petition. They're not asking for special treatment. Many have never claimed benefit and do not intend to. They're simply asking that the rules they came under are upheld. A constituent of mine, Amandeep, an engineer, told me his employer will not sponsor him for 10 years. He has a young baby, a point made by my honourable friend. Forcing him to leave would destabilise his family. Pranav, 19, he has an offer from University of Oxford, but because he and his mother fall months short of the 5 years, they now face waiting another 5 years for settlement. He planned his future around the existing rules. Now that the future is in doubt, there are human consequences of shifting the goalposts mid-game. My constituents are not asking for leniency, just fairness. Britain succeeds when it rewards contribution, values fairness, and keeps its word. Yes, we must control our immigration system, but control must never come at the cost of fairness, because a country that changes the rules after people have kept them is not restoring trust, it is breaking it. Thank you.
E-picture.
Let me start by saying something I suspect most members across the House will agree on. Our immigration system does require reforming. It needs to be fair, it needs to be clear. It needs to command public confidence. That includes securing borders, proper enforcement and rules that people can understand. But we have to be honest about what today's debate is about. It is about people who came here through legal processes that Parliament set. People who have made life-changing decisions based on the rules as they stood at the time, who came here to work, who are working, doing jobs our communities rely on every single day. People who are contributing, paying taxes, raising families. Their contributions matter. They matter. They really matter. In particular, I want to focus today on care workers. The care sector is under immense pressure. Many of the people affected are doing demanding, often lower paid, but absolutely essential work, caring for our parents, our grandparents, and some of the most vulnerable people in our society. Removing certainty from that workforce risks deepening existing shortages and undermining continuity of care. Now, this debate has been prompted by petitions, including one started by a constituent of mine, and it's because of him that this debate happens in part today, and I do thank him for doing that. Lawrence Bansal is a care manager with 15 years' experience across health and social care. He came to the UK from the Philippines with a nursing background, and he later became a British citizen through the 5-year route to indefinite leave to remain. He has spoken of his deep gratitude for the opportunities that this country has given him to build a great life, to lead in care and to support vulnerable people. He's also crystal clear about what is at stake in terms of the workforce. Speaking about care workers on health and care worker visas, Lawrence says, this is not simply an immigration issue. In his words, it's one of stability, dignity, and the ability to continue caring for people who rely on them every day. He told me that the workforce remains fragile, and he's clear about the risks of extending settlement timelines, losing experienced staff, disrupting continuity of care, and ultimately harming the vulnerable people that the system exists to protect. Now, Lawrence is here today with the Hesley Group alongside a CEO, Virginia Perkins, and he says it's time to cement stability in social care, and he's urging government to ensure full impact assessments are completed. There is a wider point here, though, about fairness and trust in government. So my ask today to the Minister is a modest one. It's about clarity and it's about reassurance. And for sake of those affected, who we are talking about today, it's a straightforward ask to the Minister. Please provide clear guidance for people with an open application pending in the very near future. People who are imminently waiting to be told to their right to remain should not be left in limbo, unsure whether they be swept into a new regime partway through a process that they entered in good faith.
Mary Foy.
This debate is necessary because it goes to the heart of fundamental fairness. The petitions before us reflect a deep sense of betrayal felt by the people who came to this country legally, followed the rules, contributed to their communities and are now being told the goalposts are being moved. The government's proposal to double the qualifying period for indefinite leave to remain from 5 years to 10 years is not just a technical policy change. It represents a broken promise to people who did exactly what was necessary. We're talking about people who've come here, chose to make our country their home, and indeed have been asked to come here by successive governments to support our public services. In the City of Durham, these are our neighbours, our teachers, the care workers and NHS staff who keep vital services running day in and day out. Last summer, I attended a Unison migrant workers event where care workers spoke to me directly about the uncertainty by these proposed changes. Migrant workers, particularly in social care, are too often trapped by sponsorship rules that tie their legal status to... Oh, okay.
Thank you very much. I was at the same conference as my honourable friend, and the issue with regard to the certificates of sponsorship is a real issue because of abuse and exploitation. Does my honourable friend agree with me that the certificates of sponsorship should be decoupled from employers to avoid any exploitation by bad employers?
Thank you for that intervention, and of course that was a fantastically informative a meeting that we went to, and I couldn't agree more with that. Because in practice, what it means is that a migrant worker, particularly care workers, are living under conditions that resemble indentured labour. And when settlement is pushed away, further, that vulnerability is prolonged. By extending the route from 5 years to 10, we're effectively handing a bad boss 10 years of leverage instead of 5 years. And I've heard directly from John, who's in the public gallery today, and he's a care worker who's living in my constituency. For 3 years, John has cared for vulnerable residents in understaffed care homes, working long hours and without complaint. And even when he was treated badly by his sponsor or placed in an emotionally demanding situation, caring for people with advanced dementia, he carried on because he believed that there was a fair endpoint. And he described the shock he felt when he learned that the route to settlement could be extended to 10 years. That change affects not just his immigration status, but his child's stability, his family's well-being, and actually whether he feels wanted in the country he serves. The government argues that settlement is a privilege. I would argue that it's a common-sense investment in a stable society. When people feel secure, they invest in their homes, they put down roots, they integrate and they contribute more fully to their communities. So I urge the government to think again, protect the 5-year route and ensure that the UK remains a country where if you work hard and follow the rules, you're met with fairness and compassion.
Thank you. Rachel Maskell.
Thank you, Ms Lowe. It's a pleasure to see you in the chair. My word is my bond, and when we break our word, we break our bond, not just with those people which have trusted in our country, given up their lives and come to serve us, but also across society as a whole, something we're really challenged with at this time, and therefore we've got to build trust, and it starts with how we respond to this white paper. The problem at the heart of the white paper is the wrong diagnosis and the wrong cure being prescribed. If you prescribe the wrong medicine, you make the patient sicker, and that is exactly what will happen. We've got a serious skill shortage across our country. We know our health and care systems are creaking. We can't get the right care in the right place at the right time. We know that we need our children teaching in our schools, a generation of houses to be built and infrastructure to find its way across our country. And yet if we put those skills at risk, if we create insecurity, our economy will not function, our public services will continue to crumble, and our society will be worse off, causing more pain across those communities that desperately look to Labour to find its solution. And therefore, I say to the government, the only place where this policy belongs is in the bin. It has completely misread what the country is saying at this time. And when going through the detail, and I will be putting in a submission to the consultation around the earned settlement, I have to say it is gendered. It is built on the premise that we know it's biased against women, built on a patriotic belief that someone of a higher pay status is worth more, and instead we should be thinking about justice and fairness for everyone, ensuring no matter how much you earn, what language you speak, and of course it doesn't mention our second English language, British Sign Language, once in the report. It shouldn't matter about the contribution you make. For some people who are disabled people coming here, just being part of our communities. And of course, then going into the prejudicial rhetoric around recourse to public funds. We must be a country which shows our standards, our compassion and our morals, and this paper certainly fails on each of those criteria. What I would say to my constituents in response to this paper is my word is my bond. If these proposals progress, I will be voting against the government and ensuring many of my colleagues join me in the lobbies, because this isn't a Labour policy.
Herod Boone.
Thank you, Chair. I would like to thank the honourable friend from Folkestone and Hythe for bringing this important debate. In my Camborne, Redruth and Hale constituency, there is profound anxiety about the changes to indefinite leave to remain, and I know the Minister knows this because I've written to him on this subject already. The government's May 25 white paper sets out proposals to increase the standard qualifying period for settlement from 5 years to 10 years, with some groups potentially eligible earlier, depending on criteria yet to be developed. Whilst I am supportive of a consultation on tighter restrictions on indefinite leave to remain for people who have not yet arrived in the UK, I'm deeply uncomfortable with the principle of changing the rules for people already in the UK, who so often experience huge upheaval in order to settle in the UK. They've described to me having made decisions about work, housing, education and family life based on the existing 5-year pathway. Many have shared the emotional toll of the uncertainty they are now experiencing. They are working hard and paying their taxes in the UK, only for the goalposts to move and for the terms under which they came to the UK to change. That's not right, I'm afraid. It's not keeping our word, it's not fair play, and dare I say it, it is not British. Many of the people I've talked to in Camborne, Redruth and Hale, like as was mentioned in Folkestone and Hythe and in the Highlands, work in the NHS, social care and many in hospitality. In Cornwall, we already have chronic shortages of these types of workers. And as the Cornish population ages and birth rates fall, it seems counterintuitive to present barriers before the very people we're in more need of. What really we need is a frank, honest discussion about immigration. And while Reform, and I dare say what's left of the Conservatives, will always use this issue to promote their dog whistle dogma, it is simply a fact that the UK needs immigrants to fill our skills gaps and increase UK productivity and innovation, or we will not achieve the economic goals and our targets. The concerns relating to spiralling welfare costs and wage undercutting can and should be addressed directly as separate issues. For people already in the UK today, we need to honour the terms by which they came and need to end the pain and anxiety that they are suffering.
Patricia Ferguson.
Thank you, Ms Rowland. It's a pleasure to serve under your chairmanship. Can I firstly put on record my thanks to Favour Dadim, who's a constituent, and her colleagues at Unison's Migrant Workers Network for sharing their experiences, their views and their concerns about the proposed changes to indefinite leave to remain. I'm also grateful to the many constituents within Glasgow West who have shared their histories and their concerns, and of course grateful also to the petitioners today. One of the most important but too often undervalued roles in our society is that of the care worker, the people who look after our elderly family members and the most vulnerable people in our communities. Many of those carers are skilled, often studying and achieving NVQs to equip them to do their jobs to the very best of their ability. But in spite of their qualifications and dedication, they're just not well paid. But as 31% of those employed in the health and care sector are now from overseas, it is clear that our NHS and the care sector could not function without them. As we've heard, the government's proposals would mean that for lower paid workers in the public sector, the waiting period for indefinite leave to remain would increase to 15 years. I would suggest, though, that a person's value to our country shouldn't just be measured in terms of their salary. It should reflect their value to our society so that people working in the health and care sectors should be judged on that contribution to our society. And let's remember, the people we're talking about pay taxes, pay national insurance, and are often very constructive members of our communities too. Research undertaken by Unison indicates that of the more than 3,000 people who have come to the UK recently to work in the care sector, 15% paid money to an employer for the privilege. 31% had problems with their pay not being given to them on time, and some of them were not getting paid for travel times between care visits or were being penalised when they themselves were ill. Many reported racial abuse, including verbal and physical abuse. So I would suggest to the Minister that a reform that we could usefully put in place for these people would be to establish a better way of granting visas to such staff. Too many have visas linked to their employment but arrive to find there isn't actually a job for them, or the company holding their visa fails and staff find themselves in financial hardship. Often the threat of a visa being revoked or the worker being returned to their home country is used to stop people speaking up about poor conditions. As Unison argues, a sector-wide sponsorship scheme run by a public sector body would take away these fears and would reduce the costs incurred when a worker does move jobs. But looking at the government's proposals...
Thank you, Ms Whelan. It's a pleasure to serve under your chairmanship. I want to keep this simple. The issue today is whether or not government should change the settlement rules for people who are already here. I wish to add my voice to the chorus of those who are saying that it shouldn't. Government can change the system for the future. That's fine. Governments do that all the time. But it shouldn't change the rules for people who've already come here under one set of conditions and are now being told partway through that the deal has changed. A lot of the people affected are doing the jobs that this country relies on. They're in hospitals, they're in care homes, they're in kitchens, warehouses. They came here legally. They were told that if they worked for 5 years, they paid the taxes and they followed the rules, that they could apply to settle. So they made decisions on that basis. But now they're being told that it won't be 5 years after all, it might be 10, it might be 15. That's a whole extra chunk of someone's life left in limbo. In the interests of time, I'll cut my speech short, Ms Lewell, but none of this has to be this way. If the government wants a 10-year route for people coming to the UK in the future, I'm fine with that. That's one thing. People can make the choice to come to this country knowing that that's the rules. But the people who've already come here on a 5-year deal should have that deal honoured. So I'm asking the government to draw a clear line in this issue. New rules for new arrivals, that's fine. But don't move the goalposts for the people who are already here doing their bit for this country. Thank you.
We're in Dudgeus.
I find myself declaring an interest because I am an immigrant myself. I was born in East Africa and my parents moved to this country with my two elder brothers. We came to Wolverhampton and I am very proud to call myself a Wolfrunian, with me now having the privilege of representing the amazing people of Wolverhampton West, a community in which 1 in 4 people like me were born outside this country. This debate isn't just about politics, it's about humanity. It's about people who have fled persecution or people who we need in this country to work in our NHS, our care homes, our shops, our universities and other places, who are not just seeking a better life for themselves, but ultimately contributing to our communities and our economy, just as my family did and have been doing so. The changes we are discussing today impact real lives, and we must remember that throughout our discussions. I've had over 1,000 constituents in my constituency signing these petitions. They're wondering why people who have made this country their home are living as model citizens, earning a living, paying their taxes, and giving a huge amount back to our communities are now having the rug pulled out from underneath them. One of my constituents, Subranachu Kumar, a highly skilled worker who completed his master's degree here in the UK and is just 14 months away from reaching his settled status, now finds himself in limbo. He was planning to buy a house next year, but now feels he cannot do this. He is not asking for special treatment. All he wants is that the rules that existed when he decided to come here remain in place. Making the proposed immigration reforms retrospective not only undermines the basic premise that the law should be stable and understandable, but it destroys confidence in the entire system. And it betrays those who came into this country in good faith. To apply these rules to those who are already here and working towards their settled status is inherently unfair. Madam Chair, the strength of feeling on this debate is obvious, evidenced by the number of people here. On 17 December last year, over 800 migrant members of the largest trade union in this country, Unison, attended one of the largest lobbying events in Parliament's history, engaging with over 100 MPs. These people are here legally. We should be making it easier for them to become settled citizens, not make it more difficult. Our diversity and multiculturalism is what makes our country great. We should be protecting legal migrants, not only to enable them to better their lives, but to better our lives too, so that everyone who lives in this country, who call our home, prosper.
Jane Kirkham.
Thank you, Ms Lowell. I spoke in a previous petition debate on this topic last year, and at that point the plans hadn't been published, and I was asking for details of how the changes might affect my constituents, many of whom were very worried and had written to me. And I talked in that debate primarily about doctors and medical staff because my constituency is home to Cornwall's only acute hospital. But I've also been contacted by accountants, chefs, an electrical engineer working in tidal energy and academics, people who made very valuable contributions to their communities and call Cornwall home. We now know that under the consultation proposals, the changes will be also applied retrospectively. Some of these people have been living and working in the UK for 3 to 4 years and assumed they would soon be eligible for indefinite leave to remain. Healthcare assistants and care workers, for example, in my constituency now potentially face 15 years of uncertainty. These people came to the UK on expensive work visas with an understanding they could apply for that settled status after 5 years. As others have said, one constituent described his reaction to the proposed changes as feeling like the goalposts were constantly being moved. They've invested their hearts and their families in this country as well as their money. I've encouraged my constituents to provide responses to the consultation and to make their voices heard. And I hope that if significant concerns are being raised about these proposals being applied retrospectively, that the Minister will look at this again.
Anne Cox.
Thank you, Mr. Lord. Like many colleagues, I believe we need a migration system that's robust and fair. It needs to be robust because, like any sovereign state, the UK needs to be able to exert control over its borders, but it needs to be fair because we're a state that defends and cherishes a rights-based order. And I wanted to speak in this debate today because I have concerns about the unfairness of some of the proposed changes to the current settlement system. I don't dispute the fact that some changes are necessary. I strongly agree, for example, with that we need a complete overhaul of the way in which we issue visas to those coming to the UK to work in the health and social care sector, as many colleagues have alluded to. Unison's proposal for a sector-wide visa system to replace the current one in which individual employers issue individual visas is a very good one, and I'm pleased to welcome Unison members from Colchester in the gallery this afternoon. That's a change that would do a great deal to safeguard the rights of all those who work in that vital sector. But other proposed changes to settlement routes give me and others cause for concern. The extension to the settlement qualifying period, the raising of income thresholds, are going to impact much more heavily on those vital public sector workers that we've heard about this afternoon, workers upon whom we all rely. So I would encourage the Minister to look at extending exemptions to those proposed changes, and whilst also adding my voice to the idea that these shouldn't apply retrospectively. On the matter of exemptions, the Justice Select Committee, on which I sit, has had a productive exchange with the Justice Secretary recently on this matter. Now, he assured us that those who have come to the UK to work as prison officers will be exempted from the proposed income thresholds. I understand that parliamentary colleagues who work or previously worked in the allied health professions in physiotherapy, occupational therapy, pharmacy, as well as social work, have also been making a similar case for income threshold exemptions in those vital sectors. So I'd encourage a very close look at that. And finally, as well as being robust and fair, our migration system needs to be in step with other aspects of government policy. It needs to offer migrant workers and their families the kinds of protections that we seek to offer citizens across the country through our Employment Rights Act, Child Poverty Strategy, Vaughan strategy, Gender Equality Strategy and Homelessness Strategy. If I may, I'll write to the Minister separately to set out my concerns about what I see as a poor alignment of the current proposal with those elements of our mission as a government. Thank you.
Dr. Scott Arthur.
Thank you, Ms Newell, and you won't be surprised to hear that it's a pleasure to serve under you today. I want to start by thanking an honourable member who introduced this debate, thank the hundreds of Edinburgh South West constituents who either emailed me or took part in my survey, and above all else, thank the 350,000 immigrants who work in our NHS. And I do want to also refer members to my register of interest. I'm speaking today because I'm concerned that these proposals are going to damage our ability as a country to attract and retain talent. I think we can all agree that the UK must continue to attract and retain world-class talent in every sector of our economy. And while it is vital that we support our British-born doctors and nurses into good jobs, we must also be aware of the reliance our health and social care system has on those from overseas. In 2015, Chair, I experienced this firsthand when a doctor born overseas saved my life. His nationality was the last thing on my mind, but I did ask about what his success rate was, I have to admit. And through my work on my rare cancers bill, I've also seen how vital contributions of immigrant doctors, nurses, researchers are to cancer care in the UK. I met with Cancer Research UK today, and they say they spend just under £900,000 a year on visa costs. Wouldn't it be fantastic, Ms Lewell, if on Wednesday, World Cancer Day, the Home Office was to waive those costs? Equally, in my past life at Heriot University, I was lucky to work alongside fantastic academics from around the world, each of them contributing to research and teaching that only enriched the academic experience of the students at the university. In May, an old colleague wrote to me with concerns about the changes. He and his family had moved to Edinburgh in 2006 to take up a lectureship at Heriot University. Since coming to the UK, he's graduated over 100 MSc students and 35 PhD students, sharing his experience with others who will go on to benefit our country. Him and his wife also works on infrastructure projects for the NHS and Scottish Water. This is a couple who could choose to live anywhere in the world. So, of course, they live in Edinburgh South West, and I'm proud they do. But it's really important that we do continue to attract people like him and his wife. And he tells me that these changes although he is now a British citizen, I have to say, it does lead him to question how valued he is to the UK and his children as well. And others in his network feel exactly the same. So I do want the immigration system to work. But I think the first step in getting it to work is for the government to listen to what people are saying today. And I think, above all else, look at the consultation responses without any preconceived notions and think about what is best for our country. Thank you, Ms Lewell.
Tracy Gilbert.
Thank you. It's a pleasure to serve under your chairship, Ms Lewell. I'd like to start by thanking the hundreds of constituents from Edinburgh North and Leith who took the time to sign the petition and who have spoken to me about this issue that we're debating today. I think it's essential that we have a serious discussion about the positive impact on society and the economic benefits that immigration has for the prosperity of our country. In my Edinburgh North and Leith constituency, we see these benefits every day. Whether it's a Nigerian carer, a Spanish cleaner or an Indian doctor, they play a vital role and are valued. Many of them will be working in sectors where we have a skills shortage, and so quite literally things wouldn't move or progress without them. Skilled people coming to our country to work in the UK make financial contributions to the state. As workers with a form of temporary leave to remain, they'll have paid thousands of pounds in fees to be in the UK, and that is before taking into account any taxes they pay. Many of my constituents who have made Edinburgh their home have been in touch with me to express the uncertainty they now face. Ms Lewell, this situation is unfair. This is not just my view, but it's the view that has also been expressed in court. In the 2008 judgment of HSMP Forum Limited versus the Secretary of State, the High Court considered changes to the then highly skilled migrant programme that would have extended the period before any person could apply for indefinite leave to remain retrospectively. In this ruling, the High Court said that applying new rules retrospectively was unfair and unlawful, and that migrants had a legitimate expectation that the rules which they initially granted would continue to apply. If the changes being proposed by the government are enacted on a retrospective basis, it is likely that the High Court will take a similar view, applying the changes as it did in 2008. Established practice, backed up by the High Court, has always protected those already with the system from the effects of any new rules, and I urge the Government to uphold this principle. I'm therefore asking the Minister to ensure that those who enter the UK under the 5-year indefinite leave to remain framework will remain eligible to apply after 5 years of lawful residence, in line with the visa conditions they were originally granted, and any new policy will not be applied retrospectively.
Josh Newbury.
Thank you, Ms Lewell. It's a pleasure to serve under your chairship, and I'd like to thank my honourable friend, the member for Folkestone and Hythe, for opening the debate so thoughtfully. And I also thank the petitioners for enabling us to debate this issue. 96% of my constituents in Cannock Chase were born in the UK, and yet immigration is one of the issues most frequently raised with me. It's a debate that matters to and affects people right across the country. In recent years, rhetoric around immigration has, I believe, led to a fundamental misunderstanding of the motivations of many people who choose to make Britain their home. At the same time, legitimate concerns about the impact of migration on communities, particularly when it is rapid, have been dismissed as bigotry. This leads only to resentment, entrenchment and toxicity, so I'm glad we're having an open and respectful debate this evening. As always, I'm keen to hear a range of views, particularly from those who will be affected by the things that we discuss in this place. 2 weeks ago, I met faith leaders and members of the congregation of the Victory Church in Rugeley, most of whom work in health and social care. What they shared with me was not opposition to reform, but a need for clarity and reassurance. They could see why change is needed, and they feel that they support the concept of contribution, which they believe that they are making in many different ways. But the proposal that people in so-called lower skilled roles could face qualifying periods of up to 15 years is causing concern, particularly for those in social care. The people I met pointed out that social care requires extensive training, safeguarding responsibilities, emotional resilience and compassion, but often is not well paid, meaning that they're not going to reach the income thresholds under the government's contribution proposals. They aren't asking for special treatment. They made a constructive suggestion. Could those who demonstrate a long-term commitment to care work and continued professional development have access to quicker settlement? I hope the Minister will say something about how the contribution of social care workers in particular can be recognised. The issue I heard loudest, though, was the need for transitional arrangements. People have understandably planned their lives around the expectation of ILR after 5 years. So I hope the Minister can give us some clarity on when we'll know what these arrangements will be. Uncertainty is affecting families' ability to plan. My constituent Solomon works in social care. His daughter is currently doing her GCSEs and recently won an award for academic excellence. He fears that on the brink of getting ILR, his family could face a decade or more of uncertainty. In the interest of time, I won't. Communities like mine are asking for a system that is fair, rewards contribution and provides a clear pathway for those who put down roots and serve our country. I left Victory Church in no doubt that the people I met were making an immense contribution to our community, and I'm sure my constituents would be proud that they want to make Rugeley their home. So whilst I support the government's objectives in reforming the settlement system, I ask the Minister to ensure clarity, dignity and stability is baked in and spelled out as soon as possible. Thank you.
Christine Sullivan.
Thank you, Ms Lowe. It's a pleasure to serve under your chairship this evening. Whilst 116 people in my constituency have signed the petitions under debate today, it's the story of one Bathgate and Linlithgow constituent, I'll call her Jill, that stuck with me. And it's a story of anxiety and uncertainty for Jill, who works in social care on a health and social care visa. She described the reality that many face, low pay, unsafe workloads, and a fear about speaking up regarding conditions at work that could put her visa at risk. She made the point that these pressures have been pushing people to breaking point across the country for years. She captured exactly why this issue matters. People like Jill moved here in good faith. They brought their families, they got jobs in health and social care roles, filling the critical gaps that we have in the workforce. They're contributing to society and dutifully paying their tax. Now the goalposts are potentially being moved. Thus, I would like to press the Minister to commit to protecting those already on the 5-year route to indefinite leave to remain from retrospective changes. For workers like Jill, settlement isn't just a petition or a debate. It's whether they can plan a future in the country for which they're helping to care, whether they will have to uproot their families and leave the homes where they've created connections and communities, whether they can speak up about unsafe conditions without fear, whether the sacrifices they've made financially and emotionally will ever lead to the security they were promised. Many in this route organised their lives around the existing 5-year pathway they budgeted for visa. In the interest of time, I won't. They budgeted for visa fees, planned family life, and made long-term decisions on the understanding that after 5 years they could apply for settlement. Extending that to 10 years means 5 more years of uncertainty and thousands of pounds in additional costs. For families, that means children grown up with prolonged insecurity and uncertainty. And for workers, it means remaining tied to temporary status for a decade, severely limiting their bargaining power at work. And for our public services, it risks driving away exactly the people we can least afford to lose. Now, I'm not arguing that immigration policy can never change. I think most people here agree that it can and it must change, but there's a fundamental issue of fairness when changes are applied to people who are already here, already contributing to local and national economies and their public services. They're already well along a pathway that's clearly set out to them, and we should not and must not pull the rug from under them now.
Martin Rhodes.
Thank you, Ms Lewell. It's a pleasure to serve under your chairing. We have a health and social care system built on the commitment and skills of workers who are too often underpaid, overstretched and undervalued. Yet they contribute not only to the well-being of our society, but to the strength of our economy. In December, I met with one of those care sector workers, who is also a Unison representative in my constituency of Glasgow North. And we discussed their campaign for fairer visa rules for migrant care workers in the UK. For transparency, I would put on record my membership of Unison. Many of those working in social care are migrants who care for some of the most vulnerable and elderly in our society. If settlement is to be earned through contribution to the UK economy and society, then few have earned it more than social care and health workers. Those who came here with hopes for a better life and have spent years supporting the health and care of the nation should have that contribution recognised and valued. Progressive reform to the system is needed. Currently, as others have mentioned, a migrant care worker's visa is tied to their employer, which opens them up to potential for abuse. It creates a situation of dependency where a bad employer can exploit their staff, knowing those staff will not risk speaking out because their visa relies on that employer. This power dynamic strips migrant care workers of their bargaining power. We need to look at a rebalance of the power dynamic between migrant care workers and their employers. I would welcome a commitment from the Minister to look seriously at the potential of a sector-wide visa that avoids the pitfalls of employment-tied sponsorship in this sector. In any new immigration rules, those working in the social care sector should be given due status in decisions about indefinite leave to remain and citizenship. I urge the Government to ensure that care workers are treated not as insignificant temporary labour, but as skilled and valuable contributors to society and the economy. Whatever changes we make to our immigration system, we must ensure those contributions are recognised and respected.
Sojan Joseph.
Thank you, Madam Chair. As part of Armed Forces Parliamentary Scheme, I recently visited some of our Army training centres, and I met with a few international recruits who also concerned about future of their life in this country. Last week, as chair of All-Party Parliamentary Group on Adult Social Care, I had the pleasure of hosting an event in Parliament to mark the launch of a new report by the Social Care Institute of Excellence. The report examines what national standard of care should look like in the future National Care Service. Crucially, the report makes the point that national standards alone will not address some of the deeper challenges facing adult social care. One of those challenges is workforce shortages. Workforce shortages across adult social care have a direct impact on the quality and continuity of care that people receive. Consistency of staff is fundamental, and delivering high-quality, long-term care without a stable workforce, that continuity simply cannot be guaranteed. I support the government's ambition to reduce long-term reliance on international recruitment. It is right that we focus on building a strong, sustainable domestic workforce. But as we do so, it is essential that we do not lose the skills of those who are already working in this sector. It is equally important to acknowledge the invaluable contribution that overseas workers have made and continue to make. After the pandemic, the last government specifically encouraged overseas recruitment into social care. Many of those who came into the UK uprooted their lives and left their families. They have made sacrifices to serve in a sector that holds the well-being of our most vulnerable citizens in its hands. As we look to encourage more domestic workforce to think about pursuing a rewarding career in social care, will my honourable friend, the Minister, consider allowing those overseas care workers who are already in the country to complete the 5-year route to indefinite leave to remain? In its last annual report examining the healthcare social care sectors, the Care Quality Commission stated that vacancy and turnover rates in adult social care have continued to fall. While this is, of course, to be welcomed, it is also pointed out that vacancy rates in the sector are still 3 times higher than those in the wider job market. We should therefore do everything we can to encourage both recruitment and retention of workers. After all, retaining trained care workers is significantly cheaper and more reliable than replacing them. But if overseas workers who are already working in social care will have to wait 10 or 15 years to gain indefinite leave to remain, they may be tempted to move to other countries like Australia or Canada that often offer quicker routes to similar settlement status. Thank you.
Ewan Steenbank.
And it's a pleasure to serve under your chairmanship. I'm going to confine my remarks to the impact of ILR proposals on social care in my constituency in Scotland. Around 25% of social care workers come from other countries around the world. We need social care staff that live, work and breathe care, and with an ageing population, we need more of them. Most of these staff have diligently and with a smile on their face taken care of our families. They have all not received a good deal over the last few years, reflecting their contribution, with often inadequate pay offers, often limited to the living wage. With Falkirk's care sector, we held a round table in November on this very subject, and I thank the fantastic local social care workers who travelled down to London to speak with me before Christmas. The concern they have is simple. Employers typically only sponsor when they need to anyway. The recent rise in those coming on social care visas is due to the pay being unattractive to domestic-born workers. Every employer in the room at my round table cited immovable difficulties recruiting locally as the reason that they were pursuing sponsorship. This is unlikely to radically improve given successive paltry living wage levels being set well shy of £15 an hour and well short of a sustainable wage for attracting domestic workers en masse reliably, and morally insufficient for anyone who contributes in working in such a valuable profession. This is a push without a pull. As MPs, we are hearing directly from providers and workers that a blunt transition before further work is done to recruit a sustainable workforce, 10 to 15-year timescales for social care workers risks leaving one of the most important sectors in our country exposed against recruiting critical workers. Asha.
Many advisors write to me who are on the skilled worker visa programme, and they're being told that they're already on a 5-year programme, that it will be changed retrospectively to a 10-year programme. Do you think there's an inherent issue of fairness here, of retrospectively making changes, and the government should at the very least have transitional arrangements?
I agree with my honourable friend's point, and glad that he managed to get it on the record, whilst also reflecting that there will be an economic impact on social care if we're not able to attract a sufficient domestic workforce to compensate for those who would leave the country. This would risk deterring those already in the sector from staying and failing to be able to replace them. It risks worsening standards for those within the industry by extending their link and unbreakable tie with a sole sponsored employer or occupation. The Government are right to pursue measures that reduce net migration, to address the lack of public consent in the immigration system due to the scattergun rise in net migration under the previous Government, who promised for years the exact opposite. But as we seek to invest in upskilling a generation, we must invest in increasing social care pay to a competitive level so that we can deliver for that sector and not risk the sector by trading off the short-term welfare of those who work in it as we pursue the direction of reducing net migration. Thank you, Ms Lowe.
Sarah Hall. Thank you, Ms Lowe. It's a pleasure to serve under your chairship. I want to speak today for my constituents in Warrington South who did exactly what this country asked of them. They came here legally, they worked hard, they paid their taxes, they built lives on the clear understanding that after 5 years they could settle. And now, partway through that journey, as we've heard time and time today, again today, the goalposts are being moved. I've met and heard from NHS clinicians, care workers, engineers, researchers, academics, teachers and other skilled professionals. Some are only weeks away from being able to apply for settlement under the current rules. These are people who kept services running through COVID, people who pay thousands in tax, and yet many are now living with anxiety and despair. Parents have asked me how they explain this to their children, children who feel British because Britain is all they've ever known. These are households already paying more into the system than they take out. Now, I understand the government's desire to reward contribution and support integration, but my constituents are struggling with a system that feels increasingly detached from the reality of their lives. Government power comes with responsibility, especially when people have arranged their lives around our decisions. We cannot invite people in on one set of rules, benefit from their labour and commitment, and then rewrite the contract halfway through. Recently, I attended a community meeting at the Gurdwara in Warrington with constituents who arrived in the UK from South Asia, members of the Sikh, Muslim and Hindu communities, all of whom came here in good faith. Every person in that room was at a different stage of the journey, and every single one would be affected. Some of the concerns that came up, a single national income threshold that ignores regional pay differences, people working full-time in vital jobs here in Warrington who cannot simply magic their wages up to a national figure. Many describe normal career progression in highly skilled roles starting lower and growing quickly, while others explained how visa restrictions limit their ability to move into higher paid work. I've spoken to couples where both parents work and pay tax, yet neither earns enough individually to qualify. Highly skilled public sector workers, I'm going to carry on to make time, sorry. Highly skilled public sector workers who are being told that their day job somehow isn't contribution enough. I've heard from researchers and lecturers strengthening our universities and innovation base, yet falling short of blunt thresholds. I want to be clear about what fairness looks like. No retrospective changes for people already on the route to settlement, clear guaranteed transitional protections and recognition of regional pay differences. We should manage and control migration, and our constituents rightly expect that. But they also expect fairness. They expect a system that recognises the contribution of hard-working, tax-paying people who now call Warrington their home. So I'm asking the government to match that same sense of fairness, protect those already on the 5-year route, recognise real contribution and give families the certainty they deserve.
Liberal Democrat spokesperson, Will Forster.
Thank you, Ms Yule. It's a pleasure to serve under your chairship this evening. The Liberal Democrats and I are completely opposed to these sudden and retrospective changes to the entitlement to indefinite leave to remain. Families who have worked hard, paid taxes and integrated into British society should not face more years of insecurity and additional costs. I will give way.
Wilson.
Thank my honourable friend for giving way. As well as the uncertainty caused by the extension from 5 years to 10 years for qualification for ILR, will he agree with me that many families in my constituency of Twickenham who've contacted me are concerned where one parent has stayed at home to look after children and therefore will not meet the minimum £12,500 threshold for permanent residence and as such therefore face massive childcare costs if they're now forced to go out to work?
I want to thank my honourable friend for Twickenham for highlighting that. She is a strong advocate for children and families, and she's quite right to highlight the government have not thought these policies through. It has a disproportionate impact, and particularly when childcare costs are so significant. And if you allow me a little while, I will move on to talking about the income thresholds changes that I don't think are acceptable. As I was highlighting, the Liberal Democrats and I do oppose these changes. This is moving the goalposts and changing the rules of the game after we have started and after we have kicked off. This goes against the fundamental British value of fairness, and that's why the Liberal Democrats and I oppose it. I do want to thank the organisers of the two petitions and all those that signed both those petitions, including and especially the 218 and 444 of my constituents of Woking. The government's consultation says that from April 2026, anyone who doesn't have their ILR status, even if their application is going through the process, will be affected. This is subject to the final outcome of the consultation, which invites views on whether there should be transitional arrangements to exempt some people already in the UK. The government press release suggests this might be considered for borderline cases. I wonder if the Minister could expand on this when he speaks later and perhaps explain, without the use of euphemisms or vague language, what that means in practice for our constituents. I think we owe it to the people of Hong Kong, Ukraine and other war-torn parts of this world who have sought refuge in Britain to respect their wish to take part in our society and allow them peace of mind to plan for the long term.
Will the honourable gentleman give way?
I will.
I thank him for giving way because he's mentioned Ukraine there, and obviously for most Ukrainians they will not be eligible for ILR as we are discussing it today. And actually this is maybe an area where we do need to see rule change because there are a lot of young people that have come over from Ukraine with their families who now know nothing other than our education system and our ways of life. So would he agree with me that it would be good for the Minister to look carefully about the approach that we take with Ukrainians?
I do agree with the honourable gentleman. If you allow me a minute, I will talk a little bit more about Ukraine. And I thought I'd be generous compared to some of his colleagues who were a bit less keen to hear from him this evening. So a bit more cross-party working, I think, Ms Yule, is in order. I want to particularly talk about Hong Kongers. Several elements of the earned settlement proposals are giving the Hong Kong community in my constituency of Woking serious cause for concern, namely vulnerable BNO families and young Hong Kong pro-democracy activists who have been forced to seek asylum here. Many BNO arrivals are full-time students, retirees, stay-at-home parents, like the Honourable Member for Twickenham mentioned, or family carers who do not meet the conventional salary thresholds. any new sustained or measurable economic contribution test or minimum income rules risk permanently excluding those entirely legitimate residents who are already fully integrated into our communities and contributing to the British society. Tens of thousands of BNO holders will reach the 5-year point and be eligible for settlement in 2026. It is appalling that that is when the government has chosen for these rules to come in. A sudden increase in B2 level language requirements without adequate notice or transition arrangements would throw many of those vulnerable individuals off balance and deny permanent status to people who have lived, worked and put down roots here for a decade. This would be yet another portrayal of Hong Kongers after the government's recent approval of the mega Chinese embassy. As my honourable friend was highlighting, moving on to Ukraine, I want to say this evening very clearly that the Liberal Democrats urge the government to take necessary steps to provide Ukrainian refugees in the UK with the stability and security they deserve by establishing a clear pathway to ILR. It's later this month that it's 4 years since the appalling and unwarranted invasion of Russia. And Ukrainian families here continue to... the appalling invasion by Russia of Ukraine. Many families have built meaningful lives here, yet their futures remain precarious due to the temporary nature of their current settled status. Reports suggest that Ukrainians are missing out on job opportunities, loans, mortgages, or lease renewals because they do not have that pathway to permanent settlement. Not only does this put them on a material disadvantage, but the pressures of securing housing or financial security under the current visa system puts refugees through huge anxiety. Their country is already at war, and it's deeply unfair to put our allies through further stress. The Ukrainian scheme is the only humanitarian scheme that does not include a pathway for settlement. Ukrainians in this country will not be able to, should not be in that position at all. Yes, we need control, but we need to have a fair system, a robust system and a frank discussion who stays and who lives on how we support our friends and allies. The Liberal Democrats are particularly concerned about the elements of Labour's proposed changes to ILR risk adding unworkable red tape for businesses and for people who came here legally, undermining integration and damaging our economy. Britain is already becoming a less competitive place for science and innovation. The 5-year global talent visa now costs £6,000, around 20 times higher than our competitor countries. Cancer Research UK alone spends almost £1 million a year on visas. I know where I want their money being invested, and it is not in visas for the Home Office. Any changes aimed at control must go hand in hand with a serious plan to boost domestic skills and get more people into the jobs our NHS, our social care and economy desperately need. Before coming on to my asks to the Minister in a summary, I do want to mention the elephant in the room, or not in the room, reform. Where are they? They are missing yet another debate on immigration. The government wants to change ILR requirements because they want to look tough on immigration because they're running scared of reform. I urge the Minister and the government to speak up for our immigrant communities, highlight the benefits of immigration, and agree with me that our constituents are much more likely to be seen by an immigrant in the NHS than to be behind one in the queue. So finally, I ask the Minister, what assessment has he made of both the economic and social cost of these changes? Does he think these changes make Britain a more competitive place when it comes to securing the workforce upon which our NHS and social care are so dependent? Has he considered how these changes may damage community cohesion and integration? And does the Minister agree with me that retrospective extending indefinite leave to remain through the provision of any specific transitional arrangements hurts the many hard-working members of our society who've played by the rules and contributed greatly to our economy and culture? Since taking office, Ms Ewell, this government has performed many U-turns on high-profile issues. whether that be because they're financially foolish, morally wrong, or would be politically impossible to deliver because of a political rebellion. Unfairly, unreasonably, retrospectively changing ILR rules meets all three of them. All three. Minister, I urge you to announce today that ILR changes will not be retrospective, so that immigrant constituents of mine, of yours and of everyone in this room can serve our who have served our communities and have fled conflict can sleep soundly at night without worrying about their future. That's what you can do this evening. I urge you to do it.
Opposition spokesperson Matt Vickers.
I'd like to thank you, Ms Buck, for chairing this debate today. This House has had a great many opportunities to discuss indefinite leave to remain and its impact on people, including debates in this place on consequential matters such as those working in the healthcare sector and BNOs. Underpinning all these debates is the principles of what factors constitute a fair migration system and what does not. Many members have made impassioned arguments today about what they believe would make a fair system. However, members who participated in previous debates on this matter will be well aware that I must respectfully disagree with some of the proposals, particularly any that would create weaker criteria around indefinite leave to remain. Both petitions seek either to maintain the 5-year period or to provide exemptions to the rules that the government has set out regarding potential changes to the receipt of benefits. If we were to follow the suggestions of these petitions, it would leave the government's current proposals on settlement in tatters and wholly ineffectual. As my right honourable friend, the Shadow Home Secretary, said, when these policies were announced, there was much in these proposals that we support. That's partially because much of it was familiar from the amendments we put forward during the passage of the government's Border Security, Asylum and Immigration Act. Having spent many hours in Bill Committee discussing this legislation nearly a year ago, I can say with absolute certainty that the idea of a 10-year route to indefinite leave to remain was something we proposed and is something we continue to support. The right to citizenship and permanent residency should only go to those who've demonstrated a real commitment to the UK, and a 10-year period is clearly more reflective of the level of commitment that many in this country would accept as a reasonable timeframe, both in terms of contribution and time to settle. The British people want and demand tougher action on immigration. We believe this is a perfectly reasonable alteration to the existing system and that it puts in place more robust measures to ensure settlement is based on those making the long-standing contribution that many of us would expect. Even though we've seen falls in the levels of net migration, with the Office for National Statistics stating that decreases in work and study-related immigration continue to follow policy reforms from early 2024, the immigration figures remain historically exceptionally high, far greater than those seen before the pandemic. The government must take action to reduce immigration. That action must be taken imminently, recognising that the time frame for these changes is dictated by a significant cohort. Between 2015 and 2020, total grants of settlement were never over 100,000. In the years either side of that, with the exception of 2010, the last year of the previous Labour government, they were never more than 200,000. I will.
Does he actually recall that between 2022 and 2024, even though the number of spaces in the care sector were deemed to be between 6,000 and 40,000, his government actually made available 616,000 visas for that.
I think we've reached there's been lots of passionate debate today, well-meaning suggestions that were passionately put about suggestions for changes or exemptions to government proposals. Some of them related to salary, some of them related to age, some of them related to people's grasp of the English language, some of them referred to people's community contribution, some of them referred to the makeup of a person's family, some referred to people's role in public services. Compassion is infinite, but this country's resources are not. We need a system that's fair, for those UK citizens, including those who are currently struggling to get on the housing ladder. I'll carry on. Between 2015 and 2020, total grants of resettlement were never over 100,000. In the years either side of that, we saw, well, the last year of the previous Labour government, there were ever more than 200,000. In contrast, between 2026 and 2030, the government's earned settlement consultation sets out estimates showing far greater numbers of people being granted settlement. Its projections estimate that numbers, well, a peak could reach as high as 620,000 in 2028 and as many as 2.2 million receiving settlement over that period. This is simply not sustainable. I think we can all understand why people want to achieve settlement more quickly. No, you won't. But the policies we set must be based on what is right for our country. We should maintain our resolve and ensure that changes are enacted without creating loopholes or alternative routes beyond what the government has set out. The approach is wholly responsive to the current situation and reflects the fact that we need much stronger policies that deliver a fair system for British citizens and for those who have already legally settled in the UK. I'd like to re-emphasise the points raised when this policy was announced, such as ensuring thresholds for earnings to demonstrate net contribution set out in the consultation must be sufficiently high to ensure that those who are granted settlement contribute to this country. Furthermore, the government's own work has highlighted some of the mechanisms people use to take advantage of existing immigration rules. Therefore, I'd ask the Minister whether they've already been internally developing strong rules to ensure that adjustments to the baseline for behaviour, such as volunteering, represent a significant contribution. If we do not have sufficiently strong criteria for what constitutes working in the community, I fear these proposals would risk being undermined. The British people care fundamentally about fairness. The British people demand stronger borders. Immigration has been far too high for far too long. There are too many people who refuse to accept this simple fact. As has been said, if we fail to deal with this crisis, we'll draw ever more people onto a path that starts with anger and ends with hatred. We need an immigration system that is fair, proportionate, and that doesn't take taxpayers for a ride. For too long, the right to remain in the UK has been seen as an automatic entitlement. It's become a conveyor belt to citizenship, when UK citizenship should be a privilege that's earned through commitment and contribution to our country. The Conservatives believe that the UK is not a dormitory or a hotel. It's our home. We must make changes to indefinite leave to remain, both to respond to the levels of immigration and so that we can have a fairer system for the future. Thank you.
Minister.
Thank you, Ms Lewis. It's a pleasure to serve under your chairmanship. I'm grateful today to the petitioners I know who are in the room this evening, to my honourable friend, the member for Folkestone and Hythe, also my constituency neighbour, for sponsoring this debate, and to every single member who has contributed. It will be difficult to name all because there has been so many, and I'm grateful for that. Both petitions today relate to the earned settlement proposal set out in a fairer pathway to settlement, the command paper which the Home Secretary introduced to Parliament on the 20th of November. The proposed reforms represent the most fundamental change to the settlement system in decades and are currently subject to an ongoing public consultation that ends in 10 days on the 12th of February. We recognise how important this is to members, and indeed have seen that here today, as well as their constituents and, of course, migrants across the whole country. And we will and are listening to what is being said. I give way.
I've encouraged many of my constituents to participate in the consultation that finishes on the 12th of February. I'm concerned to hear that some of these changes may be coming in April this year. I know from past experiences that government consultations tend to take an awful long time for the government to consider the responses and then to come up with their own response to that. So how does that work in terms of the timing?
Thank you.
honourable member for her intervention. Some of the rule changes that we will be introducing are firm, and that will be laid out today in my speech, whereas much of it, for example, transitional arrangements, are very much being consulted on, and of course that will be listened to. If there's any further questions when I finish, then please do intervene nearer the end. Let me give way.
Could you just confirm whether the ones that are firm were also ones that were consulted about in the consultation document? And if so, why were they consulted about?
Honourable member for his considered intervention, and I will go through my response to the debate, which will lay out exactly what changes are being made and what is going to consultation. I'm happy to talk again at the end. We'll, of course, provide further details on the new settlement system, on how the new settlement system will work in due course after the consultation closes. But I hope members here today will appreciate that while the consultation is ongoing, I am somewhat restricted in what I can say, but I will endeavour to be as helpful and fulsome in my response as possible. This government, I won't give away, I'll make some progress so we can actually hear the meat of what I need to say. The government recognises and values the long-term contribution of migrants in the UK. This is not a deportation policy, and multiculturalism does absolutely make us great. Settlement here is a privilege and not a right. It cannot simply be a measure of how long someone has been in the UK, but rather by the contribution that they have made. If someone wants to settle in the country, they must contribute, integrate, follow our laws, and of course learn our language. These are the principles that underpin a fair immigration system that the British public can have confidence in. Net migration ballooned under the previous government, and we are now faced with the prospect of 2.2 million people being eligible to settle between 2026 and 2030. Around 1 in 30 of every person in this country arrived between 2021 and 2024. These numbers are staggering. That is not what people vote for, and I'm surprised this hasn't been raised during the debate today. Such numbers do jeopardise our public services, our economy, the housing market, cohesion in local communities, and doing nothing is simply unacceptable. 1.34 million people are currently waiting on our social housing waiting list. This has gone up 200,000. So what's that?
Order, order. Sitting is suspended for 15 minutes for a division in the House.
Oh, wasn't expecting that.
Order, order. The sitting has resumed. The debate will now continue until 7:37 p.m. Minister.
Thank you, Chair. This debate's much better organised than what we've just been through, so thank you. Now, where was I?
Can he just say from the dispatch box right now, very clearly, that any changes to ILR will be voted on by the whole House, which will give all his colleagues who are here tonight the opportunity to express their genuine hostility to these proposals. So will he confirm that now?
Thank you for your question. His question. It's likely to be on rule changes. That decision hasn't been completely made, but you can, of course, express your frustration at me here in this room today. Where was I? 1.34 million are currently on the social housing waiting list. That's increased by 200,000 since 2020. Combine that with a potential 2.2 million people being eligible for settled status between 2026 and 2030, that puts a massive strain on our public services. We have already set out plans to increase the standard qualifying period towards settlement from 5 to 10 years. The earned settlement model will allow people to earn reductions for positive behaviour, such as working in a public service role and volunteering. We want to encourage this behaviour, which underlines the substantial contributions that many migrants make to our country. People today have spoken very well about stability within the country, and what people have framed as moving the goalposts, apparently taking that stability away. But I do want to stress today that people who are here waiting to settle have access to education, have access to healthcare, to rent. They can buy a house, they can work, they can travel in and out of the country, and they have access to financial products. Like I said at the beginning of this is not about deporting, this is about creating a system that's based on contribution and integration and people who aren't committing crime. That's what the public expect. However, the new model will also impose penalties on people who claim public funds or who have breached immigration laws. These are not punitive measures. They are deterrents for those who are thinking about choosing a life of benefits when they can work, or who fund criminal gangs to cross on a small boat, endangering their own lives in the process. This government will not continue with the status quo, considering the huge numbers we face. It is right that we implement a system that is fair, that rewards people who work to make this country a better place to live. As I'm sure members are aware, proposals that are not subject to consultation are 5-year discounts for 2 groups of people. Firstly, partners, parents and children of British citizens. This reflects our commitment to treating our citizens fairly and their right to be in a relationship with whoever they choose, regardless of nationality. Secondly, British national overseas visa holders will receive the discount. We remain committed to the people of Hong Kong and the hundreds of thousands who have uprooted themselves and rebuilt their lives in the UK. Prior to this debate, I was at the APPG for Hong Kongers discussing exactly this. There are complex issues around income, family income, assets over income, and this is at consultation currently and will be announced when that decision has been made. It is vital that migration enriches our economy, but most importantly, that it enriches our local communities. The measures set out in the earned settlement model are ones that promote integration by raising the level of English required and demanding strict adherence to our laws. We will encourage integration and strengthen communities. Turning to the subject of the first petition, people who come to... I'll give way.
One of the four pillars that he has set out in the consultation document in relation to integration is about volunteering. And it's been mentioned by a number of honourable members this afternoon that there is an arbitrariness to this, a subjective nature to the issue of volunteering. Who is going to certify the volunteer work that's been done? One can imagine a plethora of organisations being set up who will happily then be able to sign a chit that says so-and-so has volunteered for so many hours a week. How is this whole process actually going to operate? Because it seems arbitrary and subjective. What will the volunteering actually entail, and how will it have to be for the home community, or will it have to be for the community, the wider community?
Thank you, Honourable Member, for his very good point there. And this is something we in the Home Office have discussed in detail many, many times. And this is why it's at consultation. It is subjective. It is complex. And right now, stood here, I can't give you a definitive answer, but we will reach that and announce that in due course. Yes, I give way.
Minister, I must disagree with much of what you've said. Most immigrants in our country are not benefits grandiers, are not criminals. In fact, most of those that I've met in my constituency surgery are hard-working people. So I ask you, just last week I had a woman and her husband and her children at my constituency surgery in tears because of the proposed policies that your government has put forward. And they tell me that both of them work full-time, and when one is working, the other one is caring. They pay into our tax system, they work most weekends, and yet they still struggle with their rent, with their food. So I ask, what point will they volunteer?
Thank you, Honourable Member, for his question. You're right, most migrants are not criminals. Most migrants are thoroughly decent people, and that's recognised by this government and, of course, by the Home Office. On the volunteering side of things, this is still a consultation, and we will set out more detail in due course. It pays me to not give more detail now, but that's where we're at.
On that issue,
Yes, I'll give way.
Alice Dodds.
Very briefly, Minister, for giving way. I wonder if you could also just clarify on a previous point, also perhaps potentially a confusion. Can you just clarify that it is most definitely not the case that all migrants go into social housing? In fact, it's pretty much the opposite a lot of the time, and in fact all of those who have contacted me about this are not living in social housing. Not that anyone should have any shame about living in social housing in the first place. And just secondly, he talked about firm elements of the government's proposals. Were they the ones about exemptions that he mentioned before, or are there other firm elements that he's going to be covering in the rest of his speech? Thank you.
Thank you, Member, for her intervention. No, I have not in any way implied that all migrants go into social housing. It's the increase of 2.2 million that would have access to that, with the already 1.34 million waiting list, and our ambition to build just 1.5 million in that picture simply isn't enough, and that's just on social housing. What we are firm on at this point... yes,
Tony Vaughan.
I'm grateful to the Minister. But does it also not... Does the Minister actually have evidence about, how many people you think are going to switch from being, not claiming benefits to claiming benefits, or from not being in social housing to in social housing? Or is this actually just a political judgment that's being made?
Refer to you, the convention's the same as in the main chamber.
I apologise.
You're referring to myself.
I apologise.
Minister.
For his point there. Look, what I'm not going to do is make up facts and figures on the spot, but it's not in my speech, so to give you an absolute fact. But what I can say is around 15% of all on universal credit are people who are not British nationals, and I think that's a reflection on the demand that it can put on our welfare system and, of course, on housing. I'm going to make some progress at this point. Turning to the subject of the first petition then, people who come to the UK to take up a job make an important contribution to our economy and our public services, filling essential skills and labour market gaps. But for too long, sectors have become reliant on them to fill those gaps and have not invested enough in our domestic workforce. The reforms we've set out in the Immigration White Paper last year are addressing that balance. We're reversing the long-term trend of an over-reliance on recruitment from abroad, who are instead increasing investment, we are instead increasing investment in skills and training for those in the UK. We implemented the first of those reforms in July last year, raising the skills threshold back to RQF 6, or roughly degree-level occupations, leaving a short list of medium-skilled occupations deemed critical to our industrial strategy and critical infrastructure. This restored the purpose of the skilled worker route and meant a reduction of more than 100 occupations. In December, we then raised the immigration skills charge by 32%. We are presently considering the Migration Advisory Committee's review of salary requirements before making further changes, and their upcoming review of the medium-skilled temporary shortage list in the summer. I will take an intervention.
Bishop Ferguson.
I'm grateful to the Minister for taking an intervention. Given that we reckon that there's some 30% of posts in the NHS and the care sector are taken up by people who have come from overseas, at what point will his reforms, those reforms that he's referring to just now, get us to the point where we can do without those 30% of people who are currently working in the health service? It strikes me that before we do anything along these lines, he needs to do an awful lot of work with the health department to make sure that balance can be had.
Thank my honourable friend for her point well made, and I can assure you that work is going on. I will come to that shortly in my response. I just want to address some of the questions that members have raised at this point. One of them is on an impact assessment. It's important that that is produced and made public, and that will come once the consultation is ended and once we've made all the final decisions. It's really important that we are matching the migration market with the skills market and, of course, the jobs market. And we are working hard in the Home Office across department to ensure that we're attracting the right workers to fill the jobs that we need to work. But I'll turn now to care workers. This government is immensely grateful to those who come to the UK with good intentions and continue to play a vital role in the adult social care sector. However, it is clear that international recruitment went too far and the route admitted unprecedented numbers of migrants and their families. As the right honourable member for Brent West, made well earlier, there was around 600,000 migrants coming to the country to fill just 40,000 roles in this sector.
Does he share with me a certain sense of irony that the former Home Secretary and the former Immigration Minister, who were responsible for giving those 616,000 visas out, have now joined Reform?
Right honourable friend for his point, very well made, and this place never ceases to amaze me. That's politics, I think. Some have raised during the debate the Unison's campaign around sector-wide visas. There is a commitment within the Immigration White Paper looking at how we make it easier for these workers to change employer. So that is being looked at seriously within the consultation. However, we do want to, of course, retain that ability to punish those dodgy employers who are dishing out visas when they clearly shouldn't be. This government is committed to providing opportunities for British workers. It's only right that we reduce reliance on international workers. And last year, the Health Secretary announced a £500 million investment in fair pay agreement for adult care workers, boosting the wages of those workers across England. But we still need to act to ensure that those who did arrive, while the requirements were relaxed, earn their settlement and demonstrate that their integration and economic contribution to the UK meets the standards that we're setting. On transitional arrangements then, the petition also touches on this, and that is to say whether the proposals will apply to those already on a pathway to settlement. Now, I know that this is a hugely important issue, as we've seen here today, We've asked for views on this in the consultation, and I hope members will understand that while I understand the keen interest here, and indeed the concerns of many individuals, I cannot say anything that could prejudge the outcome of the consultation. And this will be published, of course, when it closes. There's been some really strong points made in the room today around family income, gender pay gap, those who are more vulnerable, those who are disabled, on university fees, and of course on armed forces concessions. And all of this is being considered within the consultation, and there will be more detail. And I can only apologise that I can't give you more detail on that today. I'd like to assure members that we will listen to what people tell us in that consultation before deciding how a settlement will work. Turning now to the second petition, we're considering whether benefits should only be available to British citizens and not to those with settled status, as is the case now. And I know members have concerns about this. The government has a responsibility to British taxpayers to ensure their money is spent in a fair and equitable way. It's therefore right that we reassess the point at which migrants can access public funds. We know the challenges the country faces and which this government has inherited. One of the most significant ones is a serious lack of social housing. We're taking steps to tackle the challenge, but we must be realistic. I've already set out the number of people who are expected to apply to settle over the next 5 years and under our current system. All of those people could be eligible for benefits and social housing. I'm sure many of us here today will have constituents who have spent years on the waiting list for social housing. Continuing to add to that list will not solve the problem. I'll give way on that one.
The member makes a point of the potential, and it's almost, if I may say with respect, scaremongering. Most of those people are hard-working citizens. Does he not believe that that kind of language actually raises the spectre, and it's precisely why we're sitting in this chamber? That kind of language does no justice to what's really happening out there in the community.
Thank you, Honourable Member, for his point, which I disagree with. There's nothing in my language which is raising the temperature, and he would do well to listen to my praise of migrants and the contribution, and I've made it clear that I do not think that all of those that seek to settle would seek to access the welfare system and housing system, but it's quite clear that some would, and we're already at capacity with 1.3 million of our constituents on the social housing waiting list. I've lost my place. We would like to hear views from people on this measure, and so I would encourage anyone who is interested in providing those views to do so before the consultation ends. I'm conscious of time. Before I finish, I want to express my thanks again to my honourable friend and all members who have contributed today. These are sweeping reforms, and I understand the strength of feeling toward them. I've heard the points that have been raised here, which will all feed into this important consultation. It's important that everyone who may be affected by these proposals have a fair and equal opportunity to make their voices heard. As I've set out, the consultation is currently open to all until February the 12th, and further information on how to respond and provide views can be found on the government website. We want to ensure that any decision taken has a robust evidence base and a clear understanding of how people may be affected, and that is why this can be unclear to some of our constituents at this point. Clearly, these are issues of great significance, not only in the context of the immigration system, but for our nation itself. So I say to colleagues here and across the House that we understand the importance of our task. We are determined to get this right. And as I've set out, we're proceeding with the seriousness and care that the public and Parliament rightly expect.
Tony Vaughan to wind up.
Thank you, Mr. Newell. Thank you to the petitioners and the 330,000 signatories and all honourable members who've attended today to speak in this debate over the last 3 hours. I've been struck by the fact that every single speaker in this debate, backbench member who has spoken, spoke against the retrospectivity of those measures for those already here on the basis that they undermine basic British fairness. It would seem to me that there is no basis at all to deny to apply these rules even to those who have pending applications, given that they are even closer to the point where they would otherwise benefit. There have been various points made by members here today. The differential impacts on members of the same family of different ILR qualification rules was made by various members, the member for Sheffield Central, Leeds, South West and Morley, Tunbridge Wells. And it was also said that it could lock victims into situations of domestic violence, which is absolutely right in the situations that I've worked on in the past and have seen that that is a very real threat. Honourable members talked about the increasing settlement period, which would entrench exploitation being tied to a single employer. Many honourable members talked about that. The honourable members for Witney, Glasgow West and North, Montgomeryshire, Popham, Limehouse, City of Durham, Blyth and Ashington, Leicester South. And also there was concern that these proposals will damage our ability to attract and retain the skills our country needs in a whole range of sectors: Edinburgh South West, Harrow West, Colchester, Ashford, St Neots and Midcams, Falkirk, Stourbridge, and especially in the more remote parts of the country, like my constituency of Folkestone and Hythe, as well as Orkney and Shetland, Perth and Kinross, Campbell and Redruth and others. The Minister cited the additional numbers who could qualify for ILR, but in my view, the view that this is a burden that we need to relieve ourselves of, in my view, takes too short-term and narrow a view. It assumes that migrants will switch into benefits or reliance on local authority housing, and I cannot see any evidential basis for that assertion. The Minister talked about 15% of those on universal credit are non-nationals, but if you look at the numbers who are the UK population generally who is foreign-born, is 20%, and so it would seem that that group are less reliant on benefits than the UK population as a whole. These are matters which are across the chamber today. We've heard points about the damage to community cohesion and integration. These are very real points that must be taken into account very, very seriously. It's not about reducing immigration. I think it was only the Shadow Minister that wrongly suggested that it is. It's about the settlement and who gets to belong here after they've contributed for so long. And I just want to end on this point, and it was raised by other honourable members. I think it's really important, given the strength of feeling that we've heard today, that there is an opportunity for MPs to express their views about these measures if they are to proceed in any form. A motion passed by negative resolution, I would suggest, is not an apt way to do that, but it is important that everybody who has spoken today feeds into the consultation so the views that the government have reflect the views of the country as a whole. Thank you.
The question is that this House has considered E-petition 727372 and 746363 relating to indefinite leave to remain. As many are of that opinion, say aye. Aye. Of the contrary, no. I think the ayes have it. Order, order. The sitting stands adjourned.